camera on already. Look at you, all ready and willing and able. One of these days, I'm gonna stop messing with you. It just won't be one of these days.
She always gets what's coming to her. It's okay.
Okay, let me
She gets
open
all
that
mad at me
window.
when it happens, but
I don't know what you're talking about. Okay, so that takes care of that. So why is the other screen capture not working?
running,
Um, hmm?
running.
Uh-huh. Um, so it's this one? Oh, okay. I want to watch this later. We can watch it later. I want to see what's being said there. And I think I saved that already.
I mean, we got it.
Um,
We got it now. You can load it now.
no,
Matter.
I'm not gonna play the no EBT thing
Oh,
for
I'll
stream. I'm not doing that.
give a rat's ass.
Um, and I'm not gonna. I mean, I don't think I saved that. And this wedding one seems interesting, but it's a commentary one, so that's later also. Mom is controlling and doesn't want me to be involved. I'm mad that people lift up their shirt when they're in court to wipe their face. Really?
I do that all
Sorry.
the time.
While you're in court on a Zoom,
Anywhere.
I have never seen you lift up your shirt to wipe your face.
I do it with the collar.
Yeah, he did the bottom. He did the bottom.
Oh
Nobody
no,
wants to
I
see
don't
your
do
man
that.
boobs. Like, come on. Oh, this one is short though. We might be able to squeeze this one into the longer ones.
All right.
Um, save it to that. Um, I don't want to scroll through this right now because I feel like
Yeah, don't do it
it'll
now.
just um that's gonna eat up time. All right, and you said you're starting, so playlist. Okay, the top two are the two that we were. Oh wait, no, not the top two. Karen mom wants to control a strange teen daughter's appearance and stole. Oh, I definitely want to see that one. Okay, so we'll do that one. Selfish and toxic mom, and we're gonna go all the way down here to the bottom to this 11-minute one when the guy shows his boobies on camera. Don't be.
You do realize you just said that on camera, right?
Oh, I'm okay with that.
Okay.
All right. All right, let
Okay.
me set. I'm gonna set myself to record. Okay, so I mean,
I don't.
I'm okay with
Nope. I don't. Nope.
I'm okay with man boobs. I mean, I don't know why you would show them in a court hearing, but let them fly. Let them boobies flap. Okay, sorry.
Stop it. Stop it.
Let me put my phone on vibrate. Okay.
Congratulations. I've been banned
For boobies?
for anything.
You get banned if you
Banned.
showed boobies. Actually, no. You could show your man boobs and it would be completely okay. Let me show my boobs and then yes, you would get banned.
Yeah. Okay.
I provided
Oh,
videos,
wow. That
pictures.
just started like boo. I don't know why it does that. Why does it just start? Actually, this is I think a new person that we've never watched. They don't look familiar. Anyway, whatever. Okay. We're just gonna jump right in. We're doing court cases today.
Court stuff.
Um,
We do pause for comment. You guys are welcome to, like always, welcome to comment as well. I'm paying attention to chat, so you're welcome to, comment as well, on what is in front of us.
okay.
Um, on what is in front of us.
Okay.
Um, on what is in front of us.
Okay.
Um, on what is in front of us. let's get into this.
Okay, I'm sorry. I accidentally dropped something and it messed up my full screen. Okay. So this one is mom is controlling and doesn't want me involved. And it's supposed to be an emotional child custody battle, but I mean, it's only 11 and almost 12 minutes. I don't know how emotional that can get.
Not very
Um,
long.
and it looks like there might be people sitting here that are not involved in this case, which is kind of, oh wait, I take that back. She's a professional. So the AAG, that must be the Attorney General, whatever they call those.
Yeah.
Is that Assistant Attorney General?
I
Uh,
guess so.
and she's the court reporter. So I don't know. There's two guys here that are both clearly not at work. So, okay. Sometimes I'm more curious than I need to be. But anyway, let's get it started.
I provided videos, pictures, phone calls. Uh,
See, man
she
boobs.
picked him up when she got off from work. Everything was fine.
And ma'am, is it correct that you're asking for no visitation between him and the child? We have a partial agreement on this case. It is a petition to establish the parent-child relationship. The father, Mr. Jordan, is not asking for DNA testing. There's no family violence, no non-disclosure requested. The child's last name will be changed to Grandstaff, and there will be no retroactive child support. The parties don't agree on the other issues as far as conservatorship, visitation, child support, and medical. I'll go ahead and call the parties. I call the mother, Miss Brianna Grandstaff. Miss Grandstaff, could you state your full name?
My full name is Brianna Yvonne Grandstaff.
And ma'am, what's the name of the child that you have with Dedrick Jordan?
My son's name is Ignacio Samuel Higdon.
And ma'am, how old is the child?
Today, we're diving into a heated courtroom custody battle that's about to get personal. It starts calmly as the judge introduces the case and confirms the basics: DNA, last name, no violence. But behind those formalities lies a storm waiting to break. As the mother takes the stand, tension builds. You
That
can
just
feel
scared
it.
the shit out of me.
This isn't just about paperwork, it's about pride, emotion, and control.
He is currently 3 years old.
And ma'am, how do you know that Dedrick Jordan is
Pride
the
and
father?
control, huh?
We took
All
a DNA
right.
test last year.
Okay, and that was not through the courts, correct?
Correct.
But it showed that Mr. Jordan was the father of the child?
Yes, ma'am.
Okay. And ma'am, did you hear the announcement regarding the agreed portions of the order?
Yes.
Are you in agreement to those terms of the order?
Can you repeat them for me so I make sure?
Yes. That no DNA is being requested. There's no family violence, no non-disclosure. The child's last name will be changed to Grandstaff and no retroactive child support.
Yes, I agree. Yes, ma'am.
Okay. And ma'am, the two of you agreed that there's been no family violence. Has there been any family violence in the past 2 years?
No, ma'am.
Okay. And ma'am, are you in agreement for the two of you to be appointed joint managing conservators of the child?
No, ma'am.
Can you explain to the court why you don't want to be appointed joint managing conservators?
I wish to retain my full sole conservative?
The mother begins her testimony, and you can tell she's been carrying the weight alone. She explains how the father hasn't been there, how she's managed every decision, every moment of her child's life. Her words are steady, but the emotion underneath is raw. She's not just asking for custody, she's demanding recognition. But will the judge see her strength or her stubbornness? The tone shifts, and the courtroom starts to feel colder.
Conservatorship, or how do you pronounce the word? I'm sorry.
Okay, so you want to be named sole managing conservator of the child?
Yes, ma'am.
Can you explain to the court why you don't want the father to be able to help make decisions regarding the child?
Well, it has been my sole responsibility the last 3 years, and despite my efforts to have him involved, he's fallen short on his promises, and overall it has still been left up to me. So legally, I would still like to keep that responsibility.
Okay. And there's no issues as far as family violence or child abuse or drug use or anything like that that would make you not want to have him be joint managing conservator?
No drug or family violence. No, there's nothing like that.
Okay. And ma'am, is it correct that you're asking for no visitation between him and the child?
That is correct.
Can you explain to the court why you want no visitation?
Yes, ma'am. So in the last few months, we have not seen or heard from Mr. Jordan. The last time he saw Ignacio was April 14th. Since then, he has made no other effort to see him. He claims that I am not allowing him, which is not the case. I've kept that door open. I've simply asked him to make the effort to schedule a visit, to reach out for communication. I even offered a once a week FaceTime every Sunday night before bed. He has only managed to attend one of those FaceTimes. That was at the beginning of May. Like I said, we have not seen him very often in the last few months. We have not heard from him. Other than regarding the case, he has not reached out. And the few times that he did interact with Ignacio, the weeks after or even the days after those visits, my son would.
Now things start to heat up. The mother insists on no visitation, describing her child's confusion after each meeting with the father. Missed FaceTimes, broken promises, it's all spilling out. The way she talks, you sense both pain and fear. But as she speaks, one question looms large. Is
Sounds
this
like
about
to me
protecting
that
the child
this case
or
is gonna
punishing the
be
father?
narrated.
The judge listens quietly.
This case is pretty much narrated.
Which explains why it's short, but
Uh-oh.
I don't know what to make of this one, because usually, like, when we watch stuff similar to this, you know, they're always claiming some type of domestic violence or, you know, like something that would, you know, encourage certain types of decisions. And I don't
Right.
get that from this, but she doesn't want him in part of any of the decision making. She doesn't want him to have visitation. So I guess you don't need my money then either, huh?
Right.
For child support. If I can't see my child and I can't make decisions for my child, then why am I paying for it?
Why am I
That
here?
just doesn't seem fair.
Yeah.
Like, it comes off more like you don't really want me. But, and maybe that's why this thing is happening, because of that. She already gave his defense that that she's keeping him from seeing the child.
Right.
And I'm guessing the reason that she's bringing it up is so that he doesn't have the opportunity to say it first.
Right.
Which is, I think, a manipulative tactic. So that you can create the narrative. I don't like people that create narratives about that's starting to become another pet peeve. Something that gets under my skin. You know, you're trying to make somebody look bad that you slept with, that you made a baby with. So they was good enough to sleep with and make a baby, but now they're a horrible person once the child is here? That doesn't make any sense.
Right.
Okay. Look, we're halfway done.
And every word feels heavier than the last.
Exhibit really aggressive behaviors and lash out. There were times where the teachers weren't unable to console him and he would have full-on meltdowns pretty much the entire day at school. And then he'd get home and the behavior would continue. I don't know if anything happened during the visits, the unsupervised visits at least, but my concern is that now that my son has finally calmed down and we restart the visitations, whether supervised or unsupervised, that my son's behavior will dramatically start to regress to the aggression and violence.
Okay. And ma'am, Are you aware that the father's asking for phased-in visitation with the child?
Yes, ma'am.
And that he would like supervised visitation for 7 visits?
Yes, and we have attempted those ourselves outside of the courtroom.
Okay, and that you would supervise those visits?
Yes, ma'am.
And then after 7 supervised visits, he would have unsupervised visitation?
Yes, we have tried that also.
Okay, and then he would have standard visitation?
Yes, and I do not feel comfortable with that.
Okay. And ma'am, is it correct that the child's covered through health insurance at your job?
Yes, ma'am.
And you're not asking for a reimbursement for that amount?
This is where the twist comes in. The mother reveals she doesn't even want child support. She says the father once offered to vanish completely if she stopped pursuing money. That revelation freezes the courtroom. Suddenly, this isn't just about parenting, it's about control, resentment, and a relationship broken beyond repair. As she steps down, you can feel it. The balance of sympathy
His
is
voice
starting
is
to
funny.
shift. The father's turn is coming next.
Oh,
Oh, that's good.
I've heard
And
this
ma'am, the
voice
state had
before.
calculated child support at $423 a month. Are you in agreement to that amount?
I was actually hoping to ask for no financial or child support from Mr. Jordan at all.
Okay, and can you explain to the court why you want no financial support?
As I said, I've been my son's sole primary guardian for the last 3 years of his life. I have managed to feed him, keep a roof over his head, keep him in childcare without any sort of help. When I originally filed for child support, it was under the impression that Mr. Jordan and I were working together. That quickly became just me doing everything by myself. And I would like to just continue handling my son's financial needs by myself. During our last visit, when they issued child support, Mr. Jordan privately messaged me later saying he would be willing to leave Ignacio alone, to stop interacting with him.
The father takes the stand, calm but clearly frustrated. He says everything was fine during visits, that the child was happy, that there were even videos to prove it. He denies any neglect, claiming the mother never complained until now. The contrast between their stories couldn't be sharper. He sounds composed, but under that calm you sense desperation. He's fighting not to lose his son completely. The courtroom grows tense once again.
Under the agreement that I dropped the child support order. And at first I thought that was unfair, but I think that in the end it would benefit my son the best.
Pass the witness. I called the father, Dedrick Jordan. Mr. Jordan, could you state your full name?
Dedrick J. Jordan Jr.
And sir, did you hear the agreements that were announced at the beginning of the hearing?
Yes, ma'am.
And sir, are you in agreement to those terms of the order?
Yes, ma'am.
And sir, I stated that you did not want DNA testing, is that correct?
Yes, ma'am.
And sir, is it correct that y'all had DNA testing privately?
Yes, ma'am.
And that showed that you were the father?
Yes, ma'am.
Okay. And sir, is it correct that you're asking that you be appointed joint managing conservators with the mother?
Yes, ma'am.
And sir, are you asking that there be a geographic restriction to Dallas County and surrounding counties for where the child lives?
Could you elaborate on that?
So that would mean that Miss Grandstaff can move if she needs to, but it would need to be within Dallas County or the surrounding counties.
That's fine.
Okay. And sir, has there been any family violence between the two of you?
No, ma'am.
Okay. And sir, is there any reason why you should not be appointed joint managing conservator?
No, ma'am.
Okay. Sir, is it correct that you're asking for phased-in visitation?
Yes, ma'am. For the comfort of us both.
Okay, and that's because the child has not had overnight visits with you before?
Yes, ma'am. We have, like she did state that we did try it. I'm not sure what she's talking about, his behavior change.
Now we see the father's heart on display. He doesn't argue, he pleads. He's not asking for full custody, just the chance to be part of his child's life. His voice cracks as he says, "That's all I'm asking." It's one of those moments that silences the room. You realize this fight isn't just legal, it's emotional survival. Everyone's watching the judge, waiting for the verdict that could change this family's future.
Okay. I felt a little bamboozled because we don't even get to find out what happens.
Right.
But unexpected, there's another case, which I'm assuming is by the same possible YouTuber. But this one, the title sounds interesting. Return the child now. Mom's forged signature. What does that say? Forged signature scheme. And it's exposed in court. It's only 18 minutes.
That's fine.
Is that okay?
Yeah, we can do that.
Okay.
Your Honor, I'm Mark Williamson. I represent
Yeah,
Aw,
that's about the
man,
same
it is
guy.
the same person.
Taylor Shea, the father.
It is the same guy.
Maybe his narration won't be as nah, never mind. There's no sense in hoping.
I don't know. His narration was actually spot on. That's why I didn't say anything. In the
No, it's
last
not
case,
that it's
and sometimes that's
Yeah.
gonna happen to us. You know, we're not gonna know that there's narration already. So
unless it's someone that we regularly watch, which
Right.
we've never watched this particular YouTuber before. But my concern, well, the narration doesn't bother me, but I think I'm so accustomed to us watching something through and through
right,
without the commentary
Right.
that I feel like we're missing pieces. But I guess if we are just getting the gist of it, then that's all the same.
right.
But this title was hard to refuse, right?
Yeah.
It was just too hard to refuse.
Of the child.
Thank you.
I'm Vicky Shea. I'm representing myself.
All right, so we're gonna take some testimony. It looks like an order in the suit affecting the parent-child relationship was entered by the court back on August the 24th of 2021. And there was a motion to set aside the judgment declaring that order void because at the time that the order was signed, the case had already been dismissed. Is that correct?
Well, the challenge today is to the personal jurisdiction over Mr. Shea and what the court just mentioned, which is a technicality, order of pleadings issue. So to be clear, there's the issue of can one amend their pleadings after their case has been dismissed, and would an amended pleading that's not properly before the court support any order? Our position is no. But secondly, the order should be declared void for lack of personal jurisdiction on my client due to lack of service of process, no waiver of citation, no court appearance, general appearance by my client, and the fact that he didn't sign the purported order that was entered back in 2021. So
Okay.
without those, it's our position that without jurisdiction, the court could not have entered that order.
All right, guys, buckle up because this hearing starts with serious legal heat. Attorney Mark Williamson steps up, challenging a 2021 order that was apparently issued after the case had already been dismissed. The tension builds instantly as the judge confirms this strange timeline. This isn't just a custody matter. It's a fight over whether the court even had the power to make that decision in the first place. The stakes couldn't be higher right from the start.
Okay. Thank you, counsel.
Which is true.
Let's see. Ms. Shea, did you want to go ahead and, because all you all are doing, you're giving argument of why the court should maintain this order.
It should stay maintained. He lived in my house in August the 2021 because we were taking him back and forth to work.
Your Honor, for the record, I need to object. Can I share my screen?
Yes, go ahead.
Your Honor, and while I'm doing that, I'd ask the court to take judicial notice of the contents of the file in this case.
Yes, the court takes judicial notice of all contents of the court's file. Counsel, what is
Thoroughly
your legal
confused.
objection?
Goes beyond the scope of her pleadings. She filed a response to the petition on September the 2nd, 2025, wherein she said, how can I get this to work? She said, her answer says, I'm stating the lack of sufficient knowledge to admit or deny the allegations. As far as I know, we did not have court on August 19, 2021. So for her to now suggest that she does have personal knowledge, that goes beyond her pleadings. So that's our objection.
Sustain.
Is there a glitch
Okay,
in the
Ms.
video?
Shea, let me say it to you like this. What Attorney Williamson is saying is that at the time that the court signed this order, the court lacked personal jurisdiction, meaning there was some sort of violation to his client's due process rights because he was not served with a copy of your petition or put on notice about coming to court or anything like that.
Okay, so you know that like when we watch these things, sometimes I'm a little maybe too like caught up on who's who and what's like
Right.
you know what I mean. Am I supposed to believe that this man Taylor has a child with Vicky? Cause I was thinking that the McKenna person was the mom. Cause Vicky looks like she's old enough to be his mama.
Yeah. Good point.
So I am thoroughly confused at the moment. Unless he just looks young for his age or something, but she's giving me like in her 40s or something.
Right.
I had to put that out there because, and this would imply that they were married, because they have the same last name. And the reason that the other part of it was because at first I'm like, oh, this is his mom, speaking about whatever's going on, and then his attorney objected. So that's kind of what did it in for me. I was like, wait,
like instantly objected, guys. Instantly objected.
Unless maybe his mother because the title of this is Return the Child Now, Mom's forged signature. So even the alternative of, oh, maybe that is his mother and she has like custody of his child and is an issue there is also like null and void because
right,
it says mom. Oh, I think he needs to date in his own age group right now.
Dang.
I'm so
dang.
Look, no shade, no judgment, but like as a person who doesn't know these people and I'm watching, I am thoroughly confused. Okay. Let's go back to it.
So that's what you would have to defend of why the court should maintain the order. And the order that you have was signed after this court back in 2019 signed an order dismissing the case. So your order that you have from August 24, 2021 was signed subsequent to the court dismissing the case. So you would be trying to explain to the court why the court should maintain that particular order. Does that make sense?
Yes.
Okay, so go ahead.
Okay, the Taylor Shea was living in our home in 21 in August because we were taking him back and forth to work.
Vicky Shea insists the father was living with her during the time in question, but the attorney cuts in, objecting repeatedly. The judge calmly steps in,
I'm still
reminding
confused.
everyone this isn't about who lived where. It's about legal jurisdiction. You can feel the frustration rising as emotions mix with legal boundaries, making the courtroom atmosphere tighter with every objection sustained.
Julie emailed us the paperwork under my
Objection, same
email.
objection, I'm sorry, Your Honor. This goes beyond the scope of her pleadings, her admission that she doesn't have personal knowledge sufficient enough to either admit or deny my client's allegations.
Sustain. So I guess the better way to say it, Ms. Shea, is what was going on at the time of the order is not the reason that we're here. We're here specifically on technical issues resulting in an order being signed when the court lacked jurisdiction to sign the order. So let me give you an example. I'm looking at the court's record, okay? This court back August 30th of 2019 signed an order dismissing this suit, okay?
Yes, that's back when in January 4th. Kim Cooks, I didn't know Kim Cooks dismissed it.
Okay.
This was all new to us
Okay.
as of now.
Let me just walk you through it. She dismissed the case back then, okay?
Yes.
2 years after the case was dismissed, you filed an amended petition, and then you also filed a proposed order on the suit affecting the parent-child relationship. You remember doing that?
Yes.
After you filed that proposed order, the judge back then signed your proposed order after the case had already been dismissed. So at the time that the order that you filed was presented to the court, there was no live case pending at the time. You still follow me?
Yeah, but I didn't know that case got dismissed until here recently when I got these papers. When I went down to get these papers, I did not know it was dismissed. None of us knew it was dismissed. I was getting papers for school.
Okay, understood.
Because none of us knew it was dismissed.
Okay.
And then when I got these papers, he was living in the house. He signed the paper because I had the email. He read the papers.
I'm going to object to any testimony that goes beyond the scope of her pleadings.
Sustain. So again, the court just needs to know, even if you didn't have knowledge, ma'am.
Yes.
Legally, there are certain things I'm unable to do just because the law doesn't allow me to do it because I don't have what's called jurisdiction to do so. I have to have jurisdiction to do so. So essentially, what I would need to know from you, not based on what you didn't necessarily know.
Now the real twist hits. The judge reviews the record and drops a bombshell. The case was dismissed back in 2019, 2 whole years before Vicky filed her petition. The courtroom goes quiet as she admits she didn't know. This revelation changes everything. What seemed like a routine custody dispute suddenly becomes a legal minefield, exposing how one forgotten dismissal could unravel the entire order. It's a jaw-dropping moment of truth.
Do you have any case law or anything to present to me today that would allow me to keep this order in place that was signed after the case had already been dismissed?
Like, what do you mean?
Do you have anything
Criminal?
No. Do you have something from a different court, like a court of appeals or something, where another case happened similar to this, and the higher told court that they could maintain this particular order after it was signed once the case was dismissed? Do you have anything like that?
No, ma'am. Because like I said, we didn't know it was dismissed until I got these court papers. When I got served.
Okay. Okay. Thank you so much. That answers a lot for me. Attorney Williamson?
For the record, may I call my client to testify briefly?
Yes.
All right. I'd like to call Taylor Shea.
Well, could you stop sharing your screen, Attorney
I'm
Williamson?
sorry. Yes.
Okay, you're okay.
There we go. I'm about to start sharing it again if I have permission. Mr. Shea, tell the court your name, please.
My name is Taylor Shea.
And are you the father of the child that's the subject of this case?
Yes, sir.
All right. May I share my screen, Your Honor?
You may.
All right. Okay. Let me show you what is. Stop doing this. Beg your pardon, Your Honor. All right.
Technical difficulties.
Father's 4 is Father's 4 is your requested ruling, correct?
Yes.
You're asking the court to vacate the prior order, correct?
Yes.
All right. Father's 1, that's a copy of the order that the judge signed. And I'll ask you, on the last page, did you sign that order?
No.
Is that your signature?
Yes. No.
I object to that one.
It's a different signature.
Hold on 1 second. I didn't hear any objection because everybody was speaking at the same time. Did someone make an objection?
I did because that's not his signature.
Okay, so ma'am, what is your legal objection?
I don't have it, just that the picture that's up there now is not the signatures that are on all the papers I have.
Okay, so I'm going to overrule that. Counsel, you may ask your next question.
Okay. Let me show you Father's 2. Is that your current signature?
Yes, that is my current
And if we
signature.
compare that to Father's 1, those signatures are completely different, correct?
Yes.
All right. Were you served with process for this amended motion?
No.
Did you make any court appearances for the amended motion?
Is it just me, or did it look like the signature thing never changed?
I didn't see that the signature thing had changed. You're correct. I didn't. I thought
Okay.
they were the same signature.
Okay, just making sure I'm not crazy.
No.
Did you sign a waiver of citation regarding the
No.
amended motion?
Now, if you look closer, it might not be the same signature. They might have
Are
changed.
you asking the court to vacate
Yeah.
the prior order from 2021?
Yes, sir.
In addition, we hired a handwriting expert by the name of Kirk Baggett. Is that correct?
Yes, sir.
Kirk Baggett is qualified and certified by the American Institute of Applied Science and American Bureau of Document Examiners, correct?
Yes, sir.
And we asked him to compare the purported signature on this agreed order to your signature on Exhibit 2, and we asked for his opinion, right?
Yes, sir.
And his opinion was that the signature on the order was indeed forged, correct?
Yes, sir.
And I'll pass the witness.
Okay, Ms. Shea, this is your opportunity to ask any questions of Mr. Shea based on his testimony that he just gave.
Well, Mr. Shea, on the paper I got served, why is your signature different than the one that's on the screen?
This is where the tension peaks. Taylor Shea takes the stand, testifying that he was never served, never appeared, and never signed the 2021 order. Then comes the shocker. A handwriting expert determined that his supposed signature was forged. The room freezes as Vicky disputes it, insisting the signatures match, but the judge overrules her. The truth about that one signature could flip the entire case. It's pure courtroom suspense at its finest.
They're two different signatures.
It's not my signature.
The papers I got served in August has a different signature than the signature you have on that screen that's saying that's your original signature that is in green.
Can you pull the original?
This is Exhibit A that I got served with. That is
Your
your
Honor,
signature.
objection, the document's not in evidence. That's not her Exhibit A or B.
No, it's your exhibit, but that's his signature on the papers that I got served with.
Your Honor, what she's asking my client is not an exhibit.
This is not your signature.
Okay, you all can move on to the next question, Ms. Shea. I sustain the objection.
Things take an emotional turn. Vicky admits she didn't even know witnesses were allowed. She tries to defend herself but struggles to grasp the legal side of what's happening. The judge stays patient, explaining that this hearing isn't about guilt, it's about authority. You can sense her confusion, the disbelief and the helplessness. It's the calm before the final verdict, and it's heartbreaking to watch her realize how little control she really had.
And I did not. Why?
What was the question, Ms. Shea?
I don't have any right at the moment, Your Honor.
Okay. All right, Ms. Isbell, do you have any questions?
No, ma'am.
Okay. Attorney Williamson?
Who the hell is she?
All right.
That's a good question.
Ms. Shea, this is your
Don't
opportunity
know.
to call any witnesses or give any testimony.
I didn't know we were allowed to have those today. I thought it was just us. I didn't know I was going to have witnesses.
Well, it's not required, but if you wanted to have witnesses, this would be your opportunity to do so.
Like a witness, like saying that, you know, his signature was not forged, that it was actually his signature on the paper I put in for Exhibit A.
Well, not necessarily, because remember, this motion hearing is not about what took place at the hearing, if he signed it or anything like that. It's a matter of, was he notified of any amended petition? And according to his testimony, he's saying that he wasn't and he didn't sign anything.
Well, none of us were presented with the exhibits of compliances.
Okay. Is there anything further?
No.
Ms. Isbell,
ma'am.
Attorney Williamson, is there anything further?
No, Your Honor.
Okay. So the court is going to make a finding that at the time that the proposed order was signed, the court did not have jurisdiction to sign it, considering that.
And here's the conclusion everyone's been waiting for. The judge rules that the 2021 order is void. The court never had jurisdiction in the first place. Then she adds a stern warning. Without a court order, only the parents can have the child. Anyone else holding her could face kidnapping charges. It's a shocking and powerful ending to a tense hearing. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next one.
Okay, so
You were prepared for all those interviews.
now that makes a little bit more sense. Okay, so now it makes a little bit more sense. That was his mother. And I'm assuming that maybe his mother had custody of his child or something
Maybe.
when she had no right to the child. I'm gathering that that was it.
Yeah.
Okay, so this one is Karen mom wants to control estranged teen daughter's appearance and stole $5,000 from child account. Like, wow. People in their desperation. Why am I not? Okay. Okay, so we like this person, this YouTuber, looking at legal stuff. They like to put stuff on the screen and have commentary, and we always find their commentary very entertaining.
Their commentary is
useful.
a little useful. We're not gonna necessarily read it each time, but it's there.
It's fast.
It's there. It's pretty
Yeah.
funny. The faces are kind of pretty funny. They go along with it. Yeah, all of that. So it's kind of meant to be, I think, his or her commentary, because we don't know if it's a he or she. We have no idea. But they usually just have like this kind of commentary, and it's pretty funny. It goes along well with what they're talking about usually.
Yeah. So this one is going to be 4 hearings. So that's going to be interesting too, I think, in itself. Yeah, this is it's 4 hearings in the divorce of a couple where mom is trying to hold dad in contempt for not following the court's order about sharing joints. Let's see, sharing where was I left off? Court's order about joint decision making with her. She says that dad is supposed to consult with her and inform her of what's going on. She says that he didn't tell her that her daughter had gone to a different hair salon, or that she joined the wrestling team and started driver's ed, or that she got her ears pierced, or that she was sent home from school one day for feeling sick, or that she stopped going to counseling. Wow. Okay, this is okay. She claims that just because her daughter has refused to see her for the last 2 years doesn't mean she doesn't have a right to know. Then we return for another contempt motion, this time against mom. Dad claims that mom unilaterally closed the joint credit card that the court was allowing dad to use because she didn't approve of the purchases he was making. And she also took $5,000 out of her daughter's personal bank account that dad wants replaced immediately. What does the judge think of mom's complaints and excuses? All right. I mean, kudos to the child having $5,000 in their bank account.
Right.
I didn't have that as a child.
What's a bank account? Yeah, I would have that. I think I had a bank account when I turned, 16? Because I had to go to work.
I mean, I had one. Yeah, I had one as a teen. I just never had that kind of money in there.
Yeah, that either. Like,
but I'm an only child, and I didn't have allowance. I was that child that, like, if I wanted something, I just asked for it and got it.
right.
So that there was no money for me to save. And then when I started working at 16, I didn't make that much money to save it. Well, I mean, in hindsight now, I probably should have. But like I said, kudos to a teen for having $5,000 to be stolen.
True.
All right, here goes. Everything is slagging. Okay. Karen mother wants to control a strange teen daughter's appearance and
Welcome to Looking at Legal Stuff. Today we have 4 hearings in the divorce of a couple where mom is trying to hold dad in contempt for not following the court's order about sharing joint
my
decision
camera's
making
gonna
with
be off for a
her.
little bit.
She says that dad is supposed to consult with her and inform her of what's going on. She says that he didn't tell her that their daughter had gone to a different hair salon, or that she had joined the wrestling team.
My
and
bad
started
for reading
driver's
something
ed,
that was already going to be
or that
read.
she'd gotten her ears pierced, or that she was sent home from school one day for feeling sick, or that she stopped going to counseling. She claims that just because her daughter has refused to see her for the last 2 years doesn't mean she doesn't have a right to know. Then we return for another contempt motion, this time against mom. Dad claims that mom unilaterally closed the joint credit card that the court was allowing dad to use because she didn't approve of the purchases he was making, and she also took $5,000 out of her daughter's personal bank account that dad wants replaced immediately. What does the judge think of mom's complaints and excuses? Well, let's find out.
¿Ha tenido un accidente? Comuníquese con la
come on.
de Brandon J. Broderick, con un equipo dedicado a accidentes disponible los 24 horas al día, 7
Now,
días
this
por la
commercial is
semana.
actually in
Están
Spanish. We don't
comprometidos
speak
a
it.
tratarlos con genuina
So,
empatía y
sorry,
comprensión.
folks.
I apologize for
Nuestra
that
comunidad, Brandon
because
J. Broderick se dedica a servirle a
I
nuestros vecinos. No
I
me
was in
confundamos
DR
esa-
in the summer.
Yeah, the petitioner, Sean McGill.
That's why that happened.
There'll be chapters in the description box if
I'm
you
also
want to
here,
skip
Tom.
ahead.
All right,
which
thank
we
you.
won't.
Yeah,
And
we
my
won't be.
client is appearing pursuant to the order to show cause, even though he technically has not been served with the same.
This
All
case
right,
has
so
been
I
ongoing
have
since 2021, but the first hearing since
a
the Court
believe
terminated
we're
the
working off
special support sports
a motion to show cause for contempt that
special
was
support.
filed by Miss McGill on the 14th of February. Is that correct?
Correct.
All right. So, Miss McGill, this is your motion, so you can make any argument. And I just want you to know I have reviewed everything that you filed.
Thank you, Your Honor. This is the petitioner, Sean McGill, has committed contempt of court by violating the parenting plan. He has violated the joint decision-making ordered by the court on 6/29/21. He has also violated paragraph 8, section B, number 1. Sean has also been warned by my former attorney, Ms. Blondin, by email and letter on 2/24/22, almost a year ago, for violating the parenting plan then. Yet he continues to do so, and I've had no recourse but to bring this action before Your Honor. He willfully, intentionally, and in bad faith has violated this. And unless the court steps in at this time, he's going to continue to do it. I've just recently found out that my daughter has taken driver's ed, no knowledge of it to me whatsoever. That is stipulated in the parenting plan under joint decision making. I only found out because I needed insurance papers, and I saw that her name was included on the insurance forms. That was something that I should not have missed. I should at least been informed, and he just refuses to do that. And I don't believe that he is going to continue to give me the information that is required that the court has said I am entitled to. And that's evident by him sending in a proposed order that he wants to change the parenting plan again. The joint decision making, he wants to be sole person who makes all those decisions, and that's just not fair. I just recently found out, and just because he told me that I need to go on the school site and look for my daughter's school sports, that she recently was in wrestling, and I had no idea of that either. And he's just not.
I would object to any information that's outside the scope of the declaration.
All right, that's noted. I'll let you continue. I'll only consider what has been before the court by declaration, but go ahead.
Okay. Unfortunately, me being pro se, I can't ask for fees to cover my time and my expenses. I asked the court for a civil penalty of at least $500 for Sean, the same amount he requested for attorney fees. I believe that that's only fair.
Yeah, what's wrong with being in driver's ed and wrestling?
He obviously
That's a good
doesn't know
question.
how to co-parent.
That's what just flashed across the screen.
Well, I think that's why she's been dubbed a Karen, right? I'm assuming the issue is just that she wasn't told.
I would assume so.
And she wants to be part of the decision. So maybe she wants to be a part of what driving school the child is using,
Maybe.
or what sport she's deciding to partake in. Like, do you want to pay for it too? Like,
Right.
you know, I mean, be happy that the decisions are made and you're not being asked for anything in return.
Right.
But I think what's even more interesting, because we don't know what the custody situation is here per se, but why does the father seem to have primary custody? Because that's what I'm getting. If he's enrolling her and stuff, he has primary custody.
Yes.
So what did you do, lady, to lose your parental rights? Or custody, I should say.
Right.
I also request that he provide the family app, our family wizard, and that he pays my portion of that. Maybe we can have some sort of communication that way. I don't know if that will work either. But those are the things that I'm trying to request. And another thing, I was really shocked that my daughter, or our daughter, is no longer in counseling, and that was ordered by the Judge Scudder. That was just
we know this judge.
Shocking. And, she definitely needs counseling. And I
Did Dad
believe
take
Mr. McGill would
her out of
agree to
counseling
that.
because of court?
This started when
That's
Lexi
what that
was
said.
13, so there's been a year and a half.
I just realized we know this judge. Oh, wait, is this? Yeah, this is the judge from the one with the
Yep. That was the other.
where we know.
Yep.
Yeah, where we never saw the dad. And I'm trying to picture the mother.
I don't think this is the same case. However, I think this
No,
is
no,
a
no,
different
no.
case.
It's not the same case at all. Because this is a different dad. And different name. But we watched like 14 hearings.
Right.
So that's why and you could tell this is old too because she looks young here, and I thought she looked kind of old in the whatever. Sorry.
She'll be 16 in April. And I just don't want her to come back to me one day and say, Mom, how come you didn't stand up for me? How come you didn't try to protect me? Why didn't you fight for me? And that's what I'm trying to do now. I'm just trying to have information on our daughter. I don't even have pictures of school.
If your daughter doesn't want to see you, she's not going to say that in 2 years.
That's what she was
or in the
doing.
future.
And that's a shame. It really is. I think that the petitioner has definitely talked about the divorce to our daughter, just by the things that he is saying.
Can I just object as to speculation?
I put that in my declaration.
All right, it's noted.
This is the plain facts. There's no getting around it. Sean McGill has violated the court-ordered parenting plan and should be sanctioned. And I given the relief that I requested in my motion for contempt of hearing. There's just no way around it. He has committed contempt. Thank you, Your Honor.
Thank you.
As far as housekeeping, Ms. McGill did attach to her initial declaration at page 7 a copy of the insurance binder. We're asking that be removed from the public file because there are identifiers, private identifiers that are affiliated with that document. It needs to be filed under seal. So we would ask that that be removed from the public filing and placed in the sealed filing. Second, as I noted at the top of this argument, my client has not been personally served, obviously, which is a requirement under the statute. My client, at least in his declaration, has asked that you consider striking this. Obviously, we are hearing this at this juncture. And ultimately, we're asking that the court find that Sean McGill has not willfully violated a court order. We're asking you to deny Ms. McGill's contempt request and award my client $500 in attorney's fees for having to respond to this. Clearly, when the court reviews through the parenting plan in light of the allegations by Ms. McGill, there are some conflicting provisions within this parenting plan as it relates to paragraph 14A about my client having the ability to make decisions on activities during his time, compared with the joint decision making and as well as in 14B. There's also conflicting provisions there. First off, my client is not obligated to provide documentation that is available to Ms. McGill through her own efforts. And clearly she's not made those efforts. Even in her argument, she acknowledges that she just now is finding out information, I'm assuming through Skyward, which has been available and accessible to her since her daughter's been in school in Kelso.
How is she supposed to know that the info?
And I would note that the majority of
that went by really
can't
fast.
read it. It's too small. I can't read it.
It's small for you?
Yeah.
Hold on, let me see.
No, it's nothing. It's nothing that you're doing. It's small on my screen because I'm looking at through a screen view.
How is she supposed to know that info is there for her to look at if Dad hasn't told her it exists, though?
True.
I mean, play detective? I mean, at a certain point...
Dang.
No, but at a certain point, especially if it was been a continuous situation, a person will get to the point where they're like, I'm over this.
Right.
Let me just worry about my kids. But I guess this is what this hearing is for then, right?
Right.
To make shit clear.
Right.
And then,
But that is a good question. Like, how is that supposed to know? How are we supposed to know that?
well, if it's an app that they're supposed to use for co-parenting, maybe.
Maybe.
I do like the smiley though.
Right.
So addressing each of the issues, and I would note that the majority of these issues, quite frankly, should, if anything, be time barred. They are so old that clearly, if there was an allegation, that should have been raised in a timely manner, and she has not done so. Her claim number 2 is a claim from nearly a year ago. My client tells you that Lexi signs herself up for various programs within the school district. If there is a fee, she lets him know and he provides that payment. And again, that's information that's available through the school sites. My client is not obligated to provide her with pictures. My client.
Okay, so it's a school thing. So he wouldn't have to tell her about a school thing, because as the parent, she should already know what her options are through the school district, right?
Right.
Is not obligated to take pictures on the first day of school and provide those to Ms. McGill.
Maybe not, but it's an awfully petty attitude to have towards making memories for your child. They didn't say he doesn't take pictures, he just doesn't send them to her.
Right. Right, exactly.
Those are completely frivolous requests and not contemptible action on my client's part.
Ah, damn it. I've been pausing so much. The ad's caught up to us.
Number 3, she says my client, on number 3, my position is that my client should not be found in contempt, again, for failing to provide a picture of Lexi on the first day of school. There's nothing, as I indicated, that requires him to do that. And as you can see, not only through my client's declaration, but through the guardian ad litem report, Lexi wants absolutely nothing to do with her mother. She does not want
Objection, Your Honor.
What's your objection?
Well, first of all, this is a report about contempt, not about what the guardian ad litem had to say. This is he violated these orders that were ordered by the court, not what the guardian ad litem to say. The guardian ad litem is not the judge.
Okay, that's
True.
noted. Go ahead, Ms. McLean.
As you can see from the guardian ad litem report, Lexi wants nothing to do with her mother, had been in counseling specifically because of actions involving her mother, actually missed her 8th grade graduation awards program because her mother came to that program and caused a ruckus. So this is a mother-daughter relationship that is broken. And what Ms. McGill is attempting to do is to punish my client for her own lack of parenting relationship with her daughter. So our position is that the court should not enter a finding of contempt for my client not taking a picture of Lexi and providing that to Ms. McGill pursuant to her demand. Number 4, Ms. McGill is asking that my client should be held in contempt because Lexi was out of school, and the documentation with the school clearly shows that she was sent home ill. She didn't go to a doctor's appointment because the doctor's appointment wasn't necessary. She was simply sent home ill. She stayed home. That's not a contemptible issue. Didn't require any decision making on my client's part. Number 5, 8 months ago, she asked Mr. McGill about counseling. The child had been in counseling since shortly after this action commenced. When the child turned out of counseling was a decision between the child and the counselor, not a decision between my client and the counselor, and there's been no documentation that has suggested that that was my client's decision. As the court is well aware, the expectation is that people will basically term out of counseling when they've addressed their issues, and clearly the fact that she's not had contact.
If her mother
has...
Yeah.
Oh, go ahead, I'm sorry.
If her mother has caused so much damage as you claim, then the child should be in long-term counseling. Counseling won't just fix her, which is true.
Well, okay. So, as a psychologist, right? We don't know when she came out of counseling.
True.
Right? So she could have been in counseling for a couple of years. And if her issues was her relationship with her mother, she could have worked with her counselor to move past those issues
Right.
on her own without
Right.
the necessity of a family session.
True.
That doesn't first of all, too, a therapist is only going to see you until either, and it's a couple of things. A therapist is going to see you until you've either resolved the concerns that you presented when you first came, or resolved any issues that you had in general. Because
Right.
sometimes patients, clients, they can develop new issues during the course of therapy.
True.
So that's one way for a therapist and client relationship to be dissolved. Another way is if, depending on your insurance, some people's insurance will only cover up to a certain amount of time. If
True.
you've exceeded that, then either you have to terminate therapy or pay out of pocket. And then the other is if, the patient themselves decides that they want to terminate with the therapist because for whatever their reasons are.
Right.
Those are just some of the things that it could have happened. So this YouTuber suggesting that damage with the mother should be long-term counseling. Well, short-term counseling is only like maybe 6 sessions. 6 sessions is a month and a half.
Right.
And that's if you make every appointment. Long-term can be anything beyond that. So, like, I mean,
yeah, isn't long term like a lot?
continuous.
Yeah.
But whenever a therapist works with a patient or client, they create a treatment plan.
True.
And that treatment plan sets a timeline of how many sessions they think they may need to go through, or, specific things that they might need in the counseling. Like, for instance, like, last month I had to give some patients a personality assessment.
Right.
That might be part of their treatment plan. Or some of the patients I've worked with have done career assessment. That might have been something that was in their treatment plan.
True.
It also depends on what they're presenting with, but if she doesn't have anxiety or ADHD or autism or something like that, and it's literally just her needing to work through a conflict, that doesn't guarantee that she's going to be in therapy for a long amount of time for that conflict.
True.
Once that issue is resolved, there's no need to have therapy.
Also true.
But I understand that not everybody knows that.
With her mother has removed a lot of those circumstances which required that counseling. Lexi concluded her counseling over a year ago, and clearly that's documentation and information that Ms. McGill could have obtained from the counselor had she put her foot forward in doing what she needed to do. It's not my client's obligation when those are available to her. He should not be found in contempt for that. In October of 2021, so a year and a half ago, she's now suggesting that my client should be held in contempt because Lexi missed school, again, because of illness, which is clearly identified in the school records that were accessible to her. Again, no doctor's appointment was necessary, and she's had this information now for 17 months.
Contempt for a single day sick is bizarre to me.
This type of a claim.
What are you
Clearly,
playing
we're
at,
asking the
Mom?
court not find my client in contempt. On number 7, this is the issue on the insurance. Lexi did complete driver's education. My client has not asked Ms. McGill to provide financial support. Lexi was adamant that she does not want her mom involved in any of the decisions, and this is where some of the difficulty comes in. Lexi is a very smart child. She gets excellent grades. Ms. Fellows, who completed her report and filed that back on October 12th of 21, specifically recommended sole decision-making due to the fractured mother-daughter relationship, and Ms. Fellows concludes that given no contact currently by Ms. McGill, she's had no contact with her daughter in nearly 2 years, that it would be impossible for Ms. McGill to weigh in with an informed decision on any decision-making issues relative
Right.
to Lexi. So her recommendation was
The father's just
that,
making the
McGill
daughter
be given
happy at
sole
this point.
decision-making
Right.
Since he's the only involved parent.
I agree. I
Obviously,
think the
what
father
that
is
does
just
that
making,
places my client in a
you know,
position
doing-
of violating
yeah.
a court order that requires.
It'd be different if it was a younger child.
True.
The relationship
But this
between
is
the
a
mother and daughter,
teenager.
which
True.
he has continued to do. And I would suggest that it's not appropriate to handle these issues in a vacuum, as Ms. McGill is attempting to do. In fact, it does place my client in a catch-22 because in the first instance, it involves Ms. McGill and Lexi's strong feelings against her, and it further risks damage to the mother-daughter relationship. So if my client approaches Lexi about, you know, this is a decision that needs to be made jointly, and she's adamant she doesn't want her mother involved, that's going to further fracture. And that was the findings and recommendations from Ms. Fellows. On the other hand, if you not involve her in decisions, then potentially that places my client in a situation where he isn't complying with joint decision making. So he's darned if he does, and he's darned if he doesn't. And the focus needs to be on Lexi. What is in Lexi's best interest? And in this circumstance, again, Ms. McGill is not an involved parent. That relationship has resulted in the child having counseling for an extended period of time, and the relationship still has not resolved itself. So we're asking that the court enter enter a finding that there has been no contempt, and that ultimately sole decision making should be awarded to my client given the circumstances. The next issue is in regards to haircuts. Lexi is 16 years old. She decides when she wants to get her haircut, and Mr. McGill does facilitate getting her to those haircuts, but it's Lexi who makes those decisions, as any young woman normally does.
This mom is gripping at straws here.
The next issue that she raises is this claim that my client should be held in contempt because he's gotten her ears pierced or hasn't communicated with her about getting her ears pierced, which she agreed that that could occur.
This is crazy controlling behavior by a mom to treat a 16-year-old like this over decisions she should have the freedom to make. That is true.
Lexi's ears have not been pierced. My client has not done that. Again, totally frivolous. There's no reason why we should be here on that. The next allegation is that my client should be held in contempt because he didn't facilitate Christmas gifts from her to Lexi. And again, Lexi does not want the gifts, but again, she's putting him in the middle of potentially resurfacing these ill feelings that the child has for the mother. It's the mother that needs to repair her relationship. She needs to stop putting my client in the middle of that, but that is not contemptible. And then finally, Ms. McGill suggests that my client should be held in contempt because Lexi removed herself from band and signed herself up for tennis. Again, she's a smart young lady. She's an involved young lady. She has made those determinations. My client shouldn't be faulted for those choices that the child makes when she's signing up for classes and events within the school system. Again, all of that is available to Ms. McGill if she would take her responsibilities seriously in making sure that she keeps herself apprised as is ordered in the court. Quite frankly, we see this as petty sniping. This needs to stop. We're asking that the court deny the request for contempt, award my client $500 in attorney's fees, and adopt the modification language that we've proposed, paragraph 13 of our contempt order, which allocates sole decision making to my client.
All right. Ms. McGill, any response?
I do, Your Honor. The reason that I believe that we didn't give Mr. McGill a copy of the contempt order was because he works out of town quite frequently. And I didn't think that he would be available for that. Besides, his attorney represents him, so I would assume that she would give that to him.
I don't know why they do this.
Things that I put on the motion for
It's
contempt
supposed to
were
be
examples, not
I don't
things
know.
that I was
I think it's supposed to be like a
to be a
bullet
participant
point,
in.
but I think it's
They
missing.
were to show the court how he refuses to
True.
answer just the
I
simplest
assumed
question that
it was them blocking something out,
And
but
the relationship between
Could
my
be
daughter,
also that too.
our daughter, and myself is not good. She's a teenager. She has so many influences with her right now. He works out of town most of the time. She is left at home with my mother-in-law, who doesn't like
I
me.
guess I would just interpose another objection. We're getting far afield as to the issues that are before the court, and certainly exceeds the scope of my argument.
I would agree. So let's talk about the motion for contempt.
All right. And Miss McLean went over about Lexi's illnesses. Here's the thing that I was trying to bring up with those examples. I am not notified when she's ill. I should be. I'm her mother. Whether he likes it or not, I'm her mother, and I deserve to know when she's ill. I don't find these things out unless I go on to Skyward every single day and check the attendance records. It wouldn't kill him just to say yes or no if she was ill, just to let me know for that day. It's not hard to do. Counseling was ordered by the court. I'm not a lawyer, but I would assume that if the court orders counseling, that the court is the one that would determine when it stops.
the court orders when counseling will start, but it's the therapist who decides when it should end. Duh. Sorry.
For her
And they did.
to make that decision and Mr. McGill not be a part of that, that's not
It's
very
actually
good
written on the
parenting.
screen.
I understand probably why she wants to quit the counseling. I'm sorry, I have a lot of people out on the side, if you can hear that. Her haircuts. We have been going to the same hairstylist for years and years. She knows our daughter's hair. She has difficult hair, and the
Yeah.
hairstylist knows it.
Exactly.
And that's why I asked
Stop.
to cut our
Leave her
daughter's hair,
alone.
because I was curious to find out why they didn't take her to the regular hairstylist that we normally go to. These are not frivolous questions. These are just questions that I'm asking Mr. McGill. It's not like I ask him a question every single day. I ask a question maybe once or twice a month. Things that I'm not aware of. The last one with the illness, she was sick for 3 days. I had no idea. It's not the fact that she doesn't go to the doctor. I don't need to.
If she's not dying, what do you need to know?
Lexi's private, but I think I deserve to know when she's sick.
She just wants to still be able to
With the school,
micromanage
she's saying
and
I'm
control
sniping.
everything.
There's no sniping here.
That's what
If
it
you
sounds
read the
like to
text
me.
messages
I think
that
she
I
wants
gave
to
at the
micromanage
so that you'll see
everything.
that there's no
And
sniping.
that's
They're regular questions.
not,
They're just
no.
honest, simple little questions that he could answer. And that's why I'm asking for the family.
I wonder if they
app.
have other kids.
Hopefully there can be some sort of communication between us, because evidently there's none at all. The only thing that is available to me online on the school site is whether what sports are being played. I have no idea what sports Lexi is in. And the only reason I found out about the one sport was I got online on the school site, like Mr. McGill asked me to the last communication that we had. And that's when I saw that she had done wrestling. So
She
he's not
doesn't
giving me
want
her
you coming to her
extracurricular
games
activities so
since
that I can
you caused a
be
scene last time.
Right,
And
right,
it's-
exactly.
It's just really sad that he doesn't want to do that.
And
But the fact is, Your
that
Honor,
fits.
these are not frivolous, and he did commit contempt of court for them. And the rules are the rules. He should be held accountable, because if he doesn't, it's never going to stop. He'll just keep thumbing his nose up at this court order. So I asked the court to give me the relief that I asked in my motion for contempt hearing. Thank you.
All right, thank you, Ms. McGill. I reviewed this several times, and I think, frankly, the
Mute your mic, lady. You know the lawnmowers.
different judicial officers, see different things. So my first thought was something that Ms. McLean pointed out, that it's kind of convoluted, that it says joint decision-making on all these things, but the parent that has the child in their possession, so to speak, is the one that gets to make all these decisions. That doesn't, those don't mesh. That doesn't work out. So if Mr. McGill were to follow 14A of the of the parenting plan, then he would be in violation potentially of 5A. If he follows 5A, he would potentially be in violation of not following 14A. So clearly that's an issue that needs to be fixed. I also completely and totally understand Ms. McGill's want to be at least tertiarily involved in her child's life and have this information. A lot of this, though, I would agree with Ms. McLean, is not the responsibility of Mr. McGill. There's information that can be received through the school. I think, frankly, the driver's education and driver's license, that probably should have been relayed to mom. It's specifically outlined under 5A in the parenting plan. Driver's permit and license, as is extracurricular activities and haircuts and that kind of thing. But let's be honest, some of that stuff isn't as kind of noteworthy as others. Do I see this as a willful, knowing and willful violation of a court order? I don't know that I don't think I can make that decision at this point. And I frankly don't think I can make that decision because I think there's an error in the parenting plan as it's entered, because it contradicts itself. If he does what it says in one part, then he's directly violating another part and vice versa. So Mr. McGill kind of is in a no-win situation here. That being said, I would agree with Ms. McGill that it wouldn't hurt Mr. McGill to share some of this information when she requests it. She indicates there's a few questions a month. That doesn't seem to be too much of too much to ask of Mr. McGill to let her know some of the things that she's inquiring of. Is it his responsibility to proactively reach out to her? It depends on which part of the parenting plan that's in place you refer to. So I'm not going to make a finding of contempt. I'm not going to impose any sanctions or attorney's fees for either party. I do think that we need to fix the parenting plan as it is. What is one thing you didn't touch base on is Ms. McGill's, and this is to Ms. McLean, Ms. McGill's request for some kind of a parenting app where information can be exchanged by way of our family wizard or something like that. Did you speak with your client about that, or do you have a position on that?
I don't know that I did. If the court is inclined to provide for a parenting app, I think that there are free apps out there. And certainly Ms. McGill is full-time employed and has the ability to pay for her own app. My client shouldn't be responsible for that, particularly since I still don't think she pays any child support. My client is raising this child without any financial support from her at this juncture. So if the court does order some type of a parenting app for future communications, she should be responsible to put her own bill.
Dance is more than just.
I mean, if she doesn't have a child to financially take care of, right?
Has likely contributed.
But I know, I think it's Talking Parent is free. I think they also have a paid version, but again, we're talking about a 16-year-old. I don't know that we really need a level of a parenting app in this day and age, given the fact that they do text or can text, and each party can save and print off their own text as needed.
And are we still, are we, because this is a temporary parenting plan, is that correct?
Correct.
Yes.
So we haven't, have we done an MSC? How far are we along in this process?
We've done an MSC. We were unsuccessful. I was waiting for supplemental discovery, and then Ms. Blondin was no longer Ms. McGill's attorney. So I'm thinking that we're in a position now where I'm probably close to noting this up for trial.
Okay.
I don't think we're anywhere close to trial, Your Honor.
Okay, well, I just was curious about where we're at. So on a temporary basis, I'm going to encourage Mr. McGill to respond to the questions posed by Ms. McGill in regards to your daughter. I'm not ordering that. I'm encouraging it. Ms. McGill, I'm encouraging you to sign up for any notifications from school, so you can keep track of whatever you need to keep track of, with regards to your daughter. As to your concerns for counseling, my understanding is that the counseling, that she attended counseling for, it was close to a year and a half. And it was a recommendation from the counselor that, that your daughter agreed to, no longer attend counseling. So I don't know that it was she chose to quit counseling. I think the counselor felt that she was in a place where she could move on without further need of counseling. I don't think that was a decision based on the information that was provided. I don't think that was a decision that she just got to get out of counseling. So I'm not as concerned with that as you are. My hope would be that if she expressed any need for counseling, that she would be able to jump right back into counseling if that was something she felt she needed. I am gonna repair the parenting plan as proposed by Ms. McLean. So I'm gonna limit the decision-making to match 15B or 15A, excuse me. So I'm gonna give the a decision 14, is it?
14A.
14A, sorry, I said 15B, 15A, 14A. So at this point, since she's full-time with Mr. McGill, I'm gonna give him the decision-making on a temporary basis until this matter proceeds to
You
trial.
want to just indicate at paragraph 6 that both parties request.
I figure she would give decision-making to dad. That takes some of the mom's
I struck it, but I'll just.
power away.
I'll strike it and then add denied.
Okay.
Okay, thank
Can
you.
you explain that, Your Honor, what that meant?
Which part? I'm sorry.
Striking what?
Oh, you request $500 in fees and they requested $500 in attorney's fees from you, and I'm denying both requests.
All right.
So
And-
nobody pays anybody anything for this.
Okay, and with Lexi's counseling, I was just reading what the judge had sent in an emailing to us, that the child still maintain her counseling. So that was why I had said that, because it was ordered by the judge.
I perfectly understand that. There was some supplemental information that was received, and my understanding was that it was the counselor suggested.
Okay, the next hearing on May 9th was the presentation of orders. I have that day's docket, but they do not appear. According to Odyssey, the order was signed as presented, so I don't think we missed anything. Okay, so I like that they go to the court site and go through the docket and get the forms and stuff to provide that information.
And it was agreed upon to discontinue.
I have never received any kind of information from her counselor.
I'm sure
stating
you
that.
can reach out to her counselor and request that.
Okay, and if it's not available, can I come back to the court?
Best of luck to you both.
Oh
All
shit, she
right,
cut her
McGill
off.
and McGill, 213-000-8908.
I'm here on behalf of the petitioner, Sean McGill, pardon me.
All right. And Luana McGill is present. You can hear us okay?
Yes, I can.
All right, thank you. All right, we are here on a contempt. Let me just, my computer has been awfully slow.
Another
today, so I
contempt. The last one was only a month ago.
So filed back on, I think, May 22nd. And in regards to the USAA account, hold on, I have notes on this.
Oh, the gal is there.
USAA Visa debit account and the Navy Federal Credit Union savings account. I have reviewed the declarations, the response, the SIR reply, and I am happy to hear any argument.
We are fighting over the child's bank account. I would like to know where he works, that there's a bed in the room. There's a bed. Is he in a hospital or some other type of something or other? He has on a uniform, but I can't tell what kind. Do you think he's a correctional officer? No, he can't be a correction. What kind of job would he have that he's always out of town? But looks like but you see the bed, right? I'm not crazy. You're muted.
I don't see a bed at all.
Right here, there's a bed. There's a headboard, that might not be a footboard, but there's a headboard, there's a pillow, and what looks like a bed. It's in the right-hand side of...
If that's a bed, that's the tiniest bed I've ever seen in my life.
No, it's a hospital. Like, it looks like one of those, like, hospital beds or nursing home beds. That, not a whole lot of mattress going on. Actually, that's giving me nursing home.
Probably.
But I don't think he's in a nursing home.
Yeah, probably. I don't know.
Because there's like a wall there, too, it looks like.
Yeah.
I'm sorry.
Yes, so may it please the court, on behalf of the petitioner, Sean McGill, we are asking that the court enter a finding of contempt. I do note that Ms. McGill in her responsive documentation attempted to bootstrap up some suggestions that my client should be held in contempt for various issues. I would simply ask that the court strike those considerations, one, because there's no motion filed before the court, nor an order to show cause, and I would suggest that that's not properly before the court. I would like the opportunity to provide responsive argument if the court is somehow going to consider those. But I think it's fairly basic, the two issues that are before you. One is Ms. McGill's unilateral removal of $5,000. I would like the opportunity to provide responsive argument if the court is somehow absolutely no notice to my client. But I think it's very basic, restraining orders that are in the temporary order where the parties are required to unilateral protect the assets.
I'm getting some kind of feedback.
You said I'm getting feedback?
I'm getting some kind of like multiple feedback. What the heck's going on there?
I don't hear anything.
That was weird.
On my end.
That was weird. Sorry, guys. I don't know what that was about. I managed to fix it.
Okay, sorry.
My client was going to take the monies, and of course, there's absolutely no evidence to support that claim. This matter has been pending before the court since 2021. And what you see from the bank statements are in fact deposits on behalf of Lexi. Obviously, parents have not only a fiduciary duty to the community, and obviously compounded by the fact that we've got court orders that require that they maintain assets on behalf of the community, but we also, parents have a fiduciary obligation or duty to their children as well, and that's to safeguard their children's accounts. It is very concerning, particularly in light of Ms. McGill's bank statements and what appears to be her own discretionary gambling, that if anybody potentially is at stake of harming Lexi's financial future, it would be her mother. I remind the court that at this juncture, Ms. McGill has no relationship with her child, that if anybody had a strained relationship with her mother and they have not had a visitation or contact fairly recently or fairly soon after this action was started. And you do have Ms. Fellows' guardian ad litem report and recommendations relative to that. As my client explains to you, Lexi is learning her own life skills. She's learning how to manage her money. She is going to have automobile expenses or automobile insurance expenses and the like, and this is all part of her learning process. She should be entitled to have the use of her own funds. Those, as my client tells you, were primarily birthday gifts from himself, birthday gifts from third parties, monies that she's earned and the like. So we're asking that the court order the immediate return of the $5,000. At this juncture, we have no idea where those monies are held.
You have no business touching the money when you haven't.
Deposited. We've provided with my client's initial
this feels like an attempt to control
the documentation that would be necessary
also
for Ms. McGill to sign to remove herself from Lexi's account. We think that that's important because clearly we think that she's going to take this type of action in the future. It is concerning that she provided absolutely no notice, no correspondence stating her concerns about my client's supposed actions to remove monies, which again are totally unfounded. And then we have that coupled with the issue where my client has had his USAA visa for years. And currently, or at the time, that visa interest rate was 14.65%. He had also accumulated benefits under that account, or rewards as it were. Again, without absolutely any notice to my client, he goes to use the credit card and is denied. And come to find out, Ms. McGill unilaterally closed out the USAA visa, again with no notice. And my client lost his long-term credit card. He lost that lower interest rate, and obviously we've seen interest rates skyrocket in the current financial circumstances of our country. And he also lost those reward points. So again, we're very concerned by her behavior, and
I would be pissed if I was him.
Right, exactly.
His interest
I agree
rate.
with that. And I agree with the smiley given. Because, yeah, I wouldn't be very happy either.
You can't reinstate his lost rewards. So those are lost to him and to the community in violation of the court order. And coupled with that, you have a credit card that had a balance on it that has been closed out, which provides a negative impact on my client's credit report because of the closing of an account with a balance on it. So we're asking that the court enter a finding of contempt. We want the $5,000 returned back to Lexi's Navy Federal Credit Union account. The order provides that those are to be returned no later than July 10. We're asking.
That is not giving her a lot of time.
I prepared my proposed order. I don't believe that your docket, and I think now your docket on the 11th is closed. Oh, maybe it's not. So we are asking that you set a review for July 11th at 1 o'clock to review and determine if she's complied with depositing those monies, if she's signed and delivered the documentation to remove her name from Lexi's account. We're asking that the court award my client attorney's fees and sanctions, sanctions at $200 and attorney's fees at $1,800, and that she comply with the orders in the future.
That's grimy to shut out a credit card. Like, why did the credit card, why did they even let her do that? There should have been some type of, if you have two people on an account, actually, you know what? I might have kind of did that to my boyfriend too. When I went to fix my credit, the credit fixer closed out one of my credit card accounts. And though it was not on my credit report anymore, it ended up on his. Because he was on my card. I felt so bad. Like, I felt so bad. But how could she do, like, with something, at least if it's something that has activity.
Right.
Like, and he's had it for a long time. Why wouldn't they say, hey, you need both account holders in order to do this? And because she did it without his permission, they should be able to reinstate everything back to what it was before they closed it. I can't imagine it being that hard.
Thank you. Ms. McGill?
Thank you, Your Honor. Expressed in my declaration, that savings account was a college account. It was not a personal account for Lexi. We, as responsible adults and parents, opened this account when Lexi was 1.5 years old. We put her name on this account in case of our death, and it would be easier for her to have the account. The money that was...
You don't get to retroactively call the money Your daughter has been depositing from her birthdays and call it college money.
No.
Deposited in that
You do
account
not.
was through our community money.
You're a liar.
We also deposited the money that we received from COVID. There were checks from my sister and from friends that were deposited in that account. And I've opened a custodial account to have the $5,000 deposited in. I have not deposited in that account yet because I know that Mr. McGill would accuse me of hiding the money. It is in my savings account, as I stated in my proposed order. Mr. McGill will spend that money with his desperation, as evident by his actions regarding our joint credit card. Mr. McGill intentionally made frivolous purchases and also added $3,000 of his attorney fees to our
the whole crap show in one video. Yes, please. Thank you so much. Wait, please oh, sorry.
card. I mean, that's common sense. You don't do that sort of thing.
Yep. Like, subscribe.
He just wanted
from
a
YouTube.
reaction from me, and he got it. I had no choice but to close out the account. If he would have been paying $200 as ordered by the court, it would have been paid off, and then we wouldn't be here today. Mr. McGill's maintenance. So after that was closed, I couldn't take my name off of that account because there was a balance. And if he would have paid it, then there would not have been a balance left on that account. Mr. McGill saying he didn't know he had to pay $200 a month is just plain laughable, Your Honor. His attorney should have gone over that court order with him to explain what it was that he needed to do. He didn't pay it. There were months that he didn't pay anything at all, and then he got a $25 fee for that. It affected my credit score also. I had no choice because I didn't know what he was going to do. Our credit balance, our credit was $16,500. Was going crazy spending money out of that account. And I was afraid of what he was going to do with the college fund for our daughter. So it matters in my own hands. And I did that because I'm protecting that money for our daughter.
And I bet this attorney has
no
bank statements to show he's never withdrawn anything from that account.
On that credit card. It was our joint credit card.
Yeah.
He has his own credit cards that he could have done that with, and he didn't. So I'm not understanding what the whole situation is here and why he's crying foul when he's the one that did this to himself. It doesn't make any sense to me whatsoever. And the thing with his maintenance that he says that he was reduced, he actually said I'm truce to the courts to get that done. And that will definitely be coming out in our divorce trial. This time, there's no hidden catch-22 for Mr. McGill to hide under. And regarding my spending, those monies that were taken out were at the ATMs. For them to say that that was all used in gambling is just crazy. Let me get this here real quick. Yeah. The money's taken out of the ATMs. At the casino on Mondays, they have Senior Citizen Day, and they give us all seniors a free gift. And while I'm there, I use the ATM. My bank is in Olympia or in Lansing, Washington. So I just take money out for spending money, for my entertainment, for gas, to pay my rent. I've been paying stuff cash here lately because I feel like Mr. McGill's always tried to control me.
Did she say senior citizen?
Not knowing my money is being spent.
Your child is 16. How old are you?
Control back. So I'm not understanding any of this stuff. So that's why I want the court to order him to pay the $7,000 on the credit card. He put $5,000 within 2 months on that credit card. $3,000 of it was for his attorney. He spent $552 at Walmart.com, $43 at Walmart, $156 at Walmart, $245 at Depot. He spent $767 on service and parts. It's like he brought this on himself. And then another $430 on beekeeping supplies. I mean, it makes no sense. It was frivolous purchases from the very beginning. And that's about all I have to say on that, except for them to put all those ATM things under gambling.
Fuck are you to say something is frivolous?
Ludicrous.
Right. When she's hiding the child's money in the first place.
Thank you, Your Honor.
Well, that's the thing too. She said that she took that money out with an ATM, which clearly they can look at bank statements and see where, where she took the money out of, because it'll show you,
Right,
the name or whatever. So if you took out $5,000 with your daughter's money at an ATM, or were using that $5,000 as your spending money,
right?
Aren't you doing the same thing that you don't want him to do?
Right.
But he's not doing, because he's not touching the money at all.
Right. Exactly.
And a credit card is a credit card. Like, but I guess she's trying to say that he never made any payments to the credit card. I think this lady is on something.
I wonder.
Really do.
Thank you. I guess I'm a little bit concerned. I don't see anywhere, and maybe someone can point it out to me. But my understanding was that Mr. McGill was allowed to use this joint credit card. In the financial documents that were filed, and I've looked through the documents filed by Ms. McGill and the documents filed by Ms. McLean. To be very frank, Ms. McGill, attorney's fees on credit cards are something I see every week. That's not weird. If he was making payments on it and that was his account, even though your name's on it, I don't, and I'm going through what you filed, and if you could point out what page there's a late fee, I'd like to see it. I don't.
Oh, you mean on the credit card fee? On the Visa?
Correct.
Okay, that is.
If you look hard enough, it'll appear out of nowhere.
It's your
Right.
story to tell.
The longer you keep looking, it'll show up eventually.
You see the sealed document I gave to you under.
She's still looking.
Does a late fee just pop up? Nah.
Okay, late charge. October 14th, 2022, $25 for fee and charges because it was a late charge.
Okay,
Because he
so 7 or 8 months after a late charge, you decide to unilaterally close someone's account.
No, Your Honor, I closed out this account because he was spending money on it like crazy. It's our joint account.
The request is going to be granted. You're in contempt, ma'am, and I don't know how you don't see that. You just completely closed someone's account.
It was
for
all
no
my
reason whatsoever.
too.
I understand that, but I see that he has use of that account. He's paying on that account. If there's a late fee from October, I'm sure he's taken, I don't care what, maybe at trial, it's going to matter what everybody's spending their money on, but frankly, you hurt yourself by closing that account because now the interest rates are, more of his money is going somewhere else and potentially not to your daughter or to you. Based on whatever the outcome of this case is going to be. So I'm going to make a finding of contempt. I'm also going to require that $5,000 be transferred back. Frankly, looking at both of your accounts, if you have the money to spend, I don't know that frivolous things, if he wants to keep bees or if he wants to repair a car, I don't have a problem with that as long as he's paying for it.
Right, but Your
it's
Honor,
not hurting anyone else. I don't care if you go to Mr. Bill's for $500 a month, if that's what you want to do. I don't care.
I understand.
But that $5,000 is going to go back to Lexi McGill's account and in its entirety.
This child shouldn't have to worry about her money being stolen by her own mother.
Nope.
I mean, a month ago, they discussed about how their relationship is not good. And so in order to make the relationship better, you take her money? Good job.
I'm gonna
Idiots.
I'm not gonna order a civil penalty at this phase. I am very concerned, Ms. McGill, though. This to me is, I know you feel the exact opposite, but this to me is a very blatant and direct violation of the court's orders to just unilaterally close an account, very much to the detriment of the petitioner in this case. So I am going to make a finding of contempt. I'm not going to impose any civil fees. The $5,000 needs to be. I'm talking, ma'am.
Okay,
I've
I'm
let you
sorry.
talk for a very long time.
I
Okay?
apologize.
So I'm not going to impose the civil penalty. I am going to impose the lawyer's costs and then the transfer of the money. I am not here on the 11th. I think we do have space on the 11th to do a review to just ensure that that was taken care of. So we'll set it for the 11th.
Your Honor, I'm
at
out of
1
town on
p.m.
the airplane. I'm out of town on that day.
If you've done what you need to do, then it's okay if you're not here. So as long as everything is that money, really it's just a review to make sure the money was transferred back into her account.
Is the court also ordering that she sign the release to remove her name from Lexi's account? That's at paragraph 11B.
Why don't you just close that account out?
Oh, the
Apparently You're not
attitude.
concerned about the benefits of
That's
some of the
not.
accounts
That's not
with,
her account to close out.
Navy Federal Credit Union and USAA. So I don't want to just close that account. I am signing the order as proposed.
It's a
apart from the
savings
civil
account. She's earning interest.
Thank you
All
very
right.
much.
Correct.
Good luck, everyone. We'll see you on the 11th.
Thank you.
I won't be here.
Well, hopefully you'll have completed what you needed to.
I certainly will, obey by the
All right.
court.
Oh my
All right,
God,
safe
what an
travels.
attitude.
Thank you.
And then, Ms. McLean, do you also have
Oh, it's that lady
Sean
again.
McGill and Luana McGill?
Yes, I do, Your Honor. And I don't see Ms. McGill online. I know that the last time we were before the court, she indicated that she would not be present at today's review hearing, that she was going to be on a plane. I guess the only thing that I would note is that at this
Planes have
juncture,
Wi-Fi.
she has complied with
Oh,
providing the
plain Wi-Fi run that
attorney
crap.
fee payments, the removal of her name from the child's bank account, the $5,000 deposited back into the bank account. The only thing that she hasn't complied with at this point is that she's not reimbursed my client the $33 for the rewards payment. I did on July 22nd, my assistant did on July 3rd. I'm sorry, did I say the 22nd? On July 2nd, I gave notice to her. On July 3rd, my assistant gave notice to her that we were still waiting for verification of the $33 payment so that we could strike this hearing. And she's not responded. My client has indicated he's not received that payment. So I would just suggest that the clerk's notes reflect that she's not complied with the purge requirements for paragraph 11C as far as that $33 payment.
Okay. And then would you want to set a review date again on this matter?
Yeah, we've got trials scheduled, and I think that's in October, and we can just address that at that time, so long as it's reflected in the clerk's minutes.
Okay. So we'll reflect in the court's notes that under 21300089008, Ms.
You gotta like when you have
McLean,
someone who doesn't follow
the
directions.
petitioner respondent is not present. The court did.
I feel like she did that on purpose.
yesterday, It looks like.
She did.
Receive a satisfaction of judgment for some amount.
She didn't like her last results,
$1,800
so
and then a
I'm not going to show up.
$5,000
Oh.
So that
Well,
was
no,
in the
I mean,
file,
we
but
knew
it
she
looks
wasn't gonna
like the
show up, but
outstanding issue is just
why
the
would you
further
not
amount
pay
of
the $33?
That remains outstanding. The parties can address that.
I think not paying the $33, but paying everything else is mom still trying to have control over things. But the important thing is Lexi got her money and mom's name is off her account. So, yeah.
As it shows there,
Yes.
which I can't see. It's too small
It's
for
hard
me.
to.
But
It's just basically saying like the free principal amount 5,000, interest is 12%. The interest start date was 6/28/2023.
Jeez, interest is
Attorney
12%.
fee. They said that on the last case too.
No wonder you don't want to close it.
No, No, the 12% I think is interest for this. The longer it takes them to comply, the more they gotta pay. Does that make sense? You know, like the interest will incur.
Yeah, it
The
makes
longer
sense.
it takes them to pay it back.
Yeah.
The attorney's fee was $1,800 with also 12% interest. That started on 6/28/2023. So the total was $6,800. And it says that the status date is 7/10/2023. What did she do? Pay it the fucking the day of the hearing?
Probably.
She probably did that so that they wouldn't see that it was done, and then come to court and say no, she didn't do it, and then she was literally probably setting herself up to try to make them look stupid.
Right.
People do that. We're not making that, like, people do stupid shit like that.
Yeah, true.
To try to feel like they have the upper hand.
At trial in October. Does that sound correct to you, Ms. McLean?
Sure. Thank you.
Okay.
All right. And
Beth Fellows, GAL.
thank you. And do we have Lawana McGill present?
Yes, Your Honor, I'm here.
All right, thank you.
This is the
We
pre-trial
are
management
set
hearing for their
readiness
upcoming
October
trial.
10th and trial the week of October 16th. Do we, either party have any issues or concerns about progressing to trial at this point?
I have some concerns, Your Honor.
Oh
Okay,
my
go
God,
ahead.
lady.
I have asked on a couple of occasions through interrogatories for the total amount for a retirement from 10/23/99 to 3/1/21, the date that this thing was filed. I also asked for a TSP, which is thrift savings plan total from 10/23/99 to 3/1/21. Mr. McGill, here's our problem. The court's going to have to decide what date is our separation date. So he's just sending me things that he thinks are up to the day that he says we separated and not the day that the was filed. I also asked for a vehicle title and statements of payments made and total due for the Jeep Renegade. His response is that his mother bought it in 2021. That is still during our marriage, so I haven't received anything on that. And I did ask, I sent them interrogatories on January 9th, 2023, and I have still not received anything that is up to March 1st of 2023.
March 1st, 2023 or 2021?
I'm sorry, 2021.
Okay.
2021, I'm sorry.
No, that's okay. I just wanted to confirm. Ms. McLean?
Well, this is the first I'm hearing of this. I've received no communications from Ms. McGill in regards to this. I'm just looking to see what I have online. We produced supplemental discovery answers. I'm sorry, we produced the second discovery answers on February 3rd of 2023 and provided supplemental discovery on, it looks like April 7th of 2023. I'd have to go into these files. I guess, let me look and see, because I don't remember. Bear with me just 1 minute. So it's a little difficult for me on the fly to try and address these issues. She's had 9 months to talk to me about this. I've received no communications from her in regards to this. There's been no motions to compel filed. At least my electronic file shows that we produced answers on, let's see, it looks like we produced supplemental answers on April 12th, April 7th, February 3rd.
Why is my birthday always in these court hearings?
This year. We've produced answers on February 21, 21st of 12.
Just bad luck, I guess. I don't know.
That included the VA information. I know that we produced
being honest
the
here, I don't know.
retirement documentation and TSB documentation, because all of that's been included in my ER 904 that was served on.
ER 904 stands for Washington Evidence Rule 904. In short, this evidence rule allows you to propose to the opposing party your intended exhibits at least 30 days in advance of trial. I've never heard that term
Ms.
before.
McGill. We had submitted voluminous answers back on October 27th of 2021. And so it looks like we've provided 1, 2, 3, 4, 5, 6 sets of discovery and supplemental discovery responses. So I'm not sure why this is a claim that's being made, except for the potential attempt to prolong this trial. This matter's been set for a number of months. And at this point, I guess from my perspective, we have submitted our witness list. I do anticipate calling 4 witnesses, the guardian ad litem and my client. And I just need to confirm if, one, I've never received disclosed witnesses from Ms. McGill. I'm assuming that she's only planning on calling herself.
May I reply, Your Honor?
Yes.
I will be giving them my list, but according to the court rules, I don't have to do that until 2 weeks prior to the trial.
Well,
so she will receive those 2 weeks prior to the trial, according to the virtual court's Zoom virtual trial policy, deadlines and compliance.
Well, she has an obligation to comply with discovery, and my discovery request asked her to disclose witnesses, and no witnesses have ever been disclosed, lay or expert. Obviously, I would want to have the opportunity to have that discussion with my client about whether I need to depose any of these witnesses and the like. So at this point, there have been no witnesses disclosed to me.
Imagine if every corner of your kitchen
That's not good.
was as
Just in time.
as that.
It says on here, it says exhibit and witness list. 2 weeks prior to trial, each party is to file with the court and send to the other party.
Okay, I don't need you to quote my own.
Okay.
She's nickel and diamond.
Okay, sorry.
If it was requested in discovery, then you need to respond to discovery requests. So, without forcing Ms. McLean to look through everything, I'm tempted to set pretrial over 1 week, because that's still 1 week prior to readiness, or we could pass to readiness and see where we are at that point. I'd rather have this conversation on this docket than a readiness hearing docket, though, if there's additional concerns.
Well, I still haven't, here's the last thing I received from them, and it was on February the 3rd, but it's only giving me the value of the TSB for December 31st, 2020, not March 1st, 2021. The same is also with the retirement fund. So I'm sure there's more thousands of dollars that they're not giving to me so that I can properly prepare. I'm ready for trial. I'm ready to go. I'm ready to get this thing done and over with. But I do need that documentation. So, and just the same with the vehicle. He said he sold it to his mother in 2021, but yet he's not giving me any titles or anything like that. I don't have the statement of how much she's paid for the vehicle. And this is all done through our marriage. But this is the problem, is the court is going to have to decide what our separation date is.
When did you request that information?
January 9th, 2023.
Okay.
And we have responded, Your Honor. I do have my discovery book here now. So we provided documentation to her on April 7th of 2023. We provided documentation on March 10 of 2023. We provided supplemental documentation on February 21 of 2023. And we provided the actual answers to discovery on February 3rd of 2023. There have been absolutely no communications as to any insufficiency of those 4 sets of responses to her second discovery request from December of 2023.
Yes, but the other documents that you sent me did not.
It was your job to let the attorney know about any missing information. You don't wait until you're in court to complain about the judge. Complain to the judge.
Complain to the judge.
Give me the,
Just hope I can read it right. Sorry, guys.
Of the final amount, total amount of his thrift savings plan and
practice makes perfect.
First. And also, he said that on the vehicle that it doesn't matter because it was sold to his mother during our marriage. He just refuses to give me a copy of the title and the amount of the statements.
Well, obviously, Your Honor, I'm not a mind reader. I can't know or create conflict on my own for my client. Ms. McGill needs to learn how to communicate, and she hasn't done that. So I guess since we're here, who are her witnesses that she's planning on calling, so I can decide potentially whether or not we should set this over, as you suggested, to next week, or if I need to potentially have more time with my client.
Ms. McGill, who are your witnesses?
I have no witnesses. This divorce is between myself and my husband. I'm not bringing anybody else to this trial.
Okay, so I don't think that we need another pretrial in light of that.
That is not wise.
I still don't have the answers. I still don't have the total amounts of money.
I don't think there really is anybody other than, because this is just a divorce. If it was like a custody thing, which they have a temporary custody order already.
True.
As far as I think the divorce is concerned, is probably any like assets, which I can understand her wanting to know about the vehicle, because depending on what he sold the vehicle for, she's probably entitled to half of it.
Right.
But I'm hoping, because we're not going to know, that when they do the divorce, that she don't get shit.
Right.
She don't need, there's no alimony, nothing. Because why is it taking 2 years to get divorced?
Yeah, good question.
That seems crazy.
Well, divorces can go on for a while.
Here's what I'm gonna.
Divorces can go on for years in some cases.
Yeah,
it depends on how long it's delayed. It depends on several factors. Messy divorces go on for a long time.
Yes, but clearly she's in a different residence, right?
True.
She's in a different residence, so unless she's wanting part of the house, or, well, we don't even know if he lives in a house.
Right.
But maybe they don't live in a house, because nothing's been brought up about that. But she already lives separately. She has a job. So it doesn't look like there's some extreme amount of wealth going on.
Right.
So that's why I'm saying I don't understand why it's taking so long.
Right.
Here's what I'm going to do. I am going to pass this to readiness. Miss McGill, you need to reach out to Miss McLean with specific requests of what, it sounds to me like you're just asking for 2 additional months of the TSP and the retirement account, and then some information about the car that's sold. Whatever you are asking specifically, reach out to her, request it, and then we will address this at readiness, which is set for the 10th at 11:30 a.m. If all parties are ready to go, then we'll get it set at that point in time.
So, Your Honor, the only thing that I would note is that my recollection, and I don't know if I've got that portion. I believe TSP documents, much like 401ks, are produced on a quarterly basis, and I believe we produced the last quarter, which would have encompassed the dates that she had requested. So December 31 of 2020 would have been the last quarter. So,
she's trying to go for his money.
All of the FERS documentation. We produced that to her former attorney back on March 22 of 2022, and provided service computation dates of 1998, 2010, and bear with me. Well, it was run on February 16th of 2022. So I
didn't do it.
That their calculation of incomes would have run through that date.
22 or 23?
22. These parties separated. They actually separated in 2010. This action was filed in, well, what's our cause number? 2021. It was filed in 2021. I don't have all of my files here, but my petition, at least on my end, is dated. Oh, actually, he must have filed pro se.
Yes, and we didn't separate until March 1st of 2021.
And that's disputed, but.
Yes,
in
that's
any
why the
event-
court's got to make it up.
In any event, the report that we produced from FERS is dated February 16 of 2022, a year later. So I'm not certain why we're having this discussion.
Because they gave me the amounts to 2011, not to 2021.
Well, you indicated that it was through December 31st, 2020 that you got responses, not March 1st, 2021.
Correct.
So not 2010.
2011 is where they gave me the amount for the retirement fund. I got the 2020 for the thrift savings plan.
Because what I'm getting here.
Oh shit! I went to a commercial when I paused.
Move forward.
Sorry.
Free radicals are everywhere. Protect yourself against them with POM.
Design you feel in every detail. Technology as innovative as it is effortless.
Okay, so I must be confused because she's giving amounts for 2021, right? Or is it 2010?
Okay. She was asking for, I guess, some retirement account or whatever.
Right.
Between, whatever the beginning date was, to, I'm guessing, 2021.
Okay.
And she's claiming she only got up to 2020. That's what I gained from that. But the attorney is saying they were separated since 2010, and the divorce was filed in 2021. The wife is not agreeing to that. But who's to say she wasn't delusional and thought she was still in a relationship?
Well, that's a 10-year deal. 10 years. I mean, wait a minute. That's saying a lot here.
Like I said, who's to say that she wasn't like delusional and thought that whole 11 years that he was gonna come back?
I mean, yeah.
He's the one who filed the divorce. And because they brought up like her gambling, I'm wondering if that's what broke the camel's back.
Well, I mean, that would make sense to me.
She's giving off
Because
a little cray-cray. Just a little.
I mean, that would make sense to me because that's a lot. That's too much for me.
And then that's the thing too. So the daughter hasn't had anything to do with her, even prior, because they said it's been 2 years. It was 2 years around the first hearing.
Right.
They're in September now, but if they're saying it was 2 years, that means that she was not talking to her mother potentially prior to the divorce.
No.
So, or divorce, the start of the divorce. So, it's like, lady, what did you do to your child?
Right.
Like, she had to done something.
Right.
Maybe it's the cray-cray?
That's what I say, but
Request what you think.
Or maybe she's been stealing her child's money. Who knows?
You need.
yeah.
And
Who
we'll
knows?
be back at readiness on the 10th. And if you at that point feel like you haven't received what you needed, then you can make a request for something at that point. To me, it sounds as though there's a pretty thorough exchange of information. And if you're concerned about something that the judge may not have, I'm assuming the judge will ask for whatever information that's needed at the time of trial. So I'm gonna pass this to readiness, make any requests specifically in writing to Ms. McLean as soon as possible. So if there is anything that is missing, that can be addressed as quickly as possible.
May I ask a question?
Yes.
Do I do that formally through the court, or I just send her an email?
Just send her an email.
Okay, thank you.
Okay, good luck.
And then do we know now, or will that be at the time of readiness, whether or not this would be by Zoom, hybrid, or in person?
That will be determined at readiness. And I do have it listed at a 2-day trial. If that changes, make sure to let the judicial officer on that readiness docket know.
I still anticipate it'll be 2 days.
Okay.
Perfect.
2 weeks later, they had their readiness hearing, and at that time, they were still set to go ahead with their trial. But the day before the trial was to begin, there was an order to strike, and instead a divorce decree and a final parenting plan were entered into Odyssey. I'm pretty shocked that Mom didn't force us to go to trial. She seemed hell-bent on getting her own way, but she may have finally realized that she'd done herself more harm than good with her antics, and she decided to work out an agreement with Attorney McLean.
Okay, then. Is there more?
Dad appears to have been awarded their marital residence, and the proof that she paid him the $33 she still owed him for the rewards points she canceled was the last entry in their case. I don't know why this mother and daughter are estranged, but if Mom treats her daughter the same way she was acting on the docket, then I can make a few guesses. I don't know what planet she was on when she decided taking her daughter's money was a good idea, but I don't see their relationship improving anytime soon, and I don't blame the daughter for that one bit. Thank you for watching.
Okay.
True.
So she still owes $33. And I guess she should hope that there's no interest building on that? All right, so...
Should be $93.
Let me... Okay. I'm just keeping track of the time. I want to watch this first one, but I'm gonna...
No, we got time.
Yeah, I just want to scroll and see, because that's a long one. That's a 2-hour one.
Yeah, we got time.
Okay, so this is... I'm still kind of caught up on the correctional officer one. Who got pregnant by an inmate. Like...
Oh,
Oh, this feels like such a toughie. Okay. And then there's a short one here too. So there's the son refuses to go with mom, runs away during custody.
Right.
Let's see. Why should my child support case? No. Mom's fake emergency exposed her story. Falls apart. I'm wondering if we should do some of the smaller ones.
We have a
and do,
2-hour.
like,
We
different
can do a
cases.
2-hour block.
Okay, so ex-correctional officer or the mom with meltdowns.
Correctional.
I wish I had the permission to remove this from my own list. Oh, you know what? I was gonna go to the reading thing, but...
Welcome to looking at...
Sorry. Oops.
We don't...
Okay.
Yeah.
Legal stuff. Today we have 7 hearings in a case with a couple where dad is motioning the court for primary custody, claiming mom is encouraging their son to stay primarily with her despite their 50-50 parenting plan, undermining dad during his custody time, and discussing the court case with their son. Dad claims they split up 2.5 years ago when mom lost her job as a correctional officer after she had an illicit affair with an inmate, and now they live together and have a toddler. Dad claims that their household is not a healthy environment for his children. He's concerned about drug use, TV incidents, and inappropriate behavior by this boyfriend and his daughter. Mom claims everything Dad says is exaggerated or a lie, and she can't understand why the court can't see that. She attempts to refute Dad's claims, but he has a very competent lawyer, while Mom's filing as pro se and doesn't have a clue how any of this works, leading to her constantly getting frustrated and upset. Will Mom stand a chance at proving Dad wrong, or will she have another meltdown? Let's find out.
I mean, sometimes these commercials are so perfectly inserted.
Today's version of this full case has updated graphics, commentary, and voiceovers, and it also contains a short new final update. But there are no new hearings in this video.
Going to final matter 24-3-00006-08, Swindell V. Sindana. I'm guessing at the name, apologize. All right, so, first off, I see we have Ms. McLean, and looks like we have Ms., is it Swindell? You're muted.
Yeah, it's Swindell.
Okay. All right. So, Ms. Swindell, the problem is that when I was looking at your documents, they're not sworn affidavits. And for me to consider them at all, they need to be sworn declarations, and they're not.
Okay.
So you understand that?
Yeah, I do. Is there a way I can make them sworn affidavits?
Well, you know, it's always difficult, like I have said many times, is I understand you're not an attorney, I understand you may not understand the rules, but you're held to the same standard of the rules. So let me hear from Ms. McLean in regard to that idea. Ms. McLean?
So my concern is that obviously we had Ms. Swindell appropriately served for this motion. Her responses were late regardless, and she didn't technically serve my office. She apparently had a copy delivered to my client, and I had been watching on Odyssey and observed that the documents had hit Odyssey. So that's how we became aware. Nonetheless, we've been able to put together reply documentation for my client, and given the concerns, we do believe it's appropriate to move forward.
All right. Well, I am going to move forward today because there are significant issues and concerns. But you need to understand one thing, Ms. Swindell. First off, anything you file with the court, you must serve on Ms. McLean's office, meaning you provide a copy of it to Ms. McLean's office, okay? So that's one thing. Secondly, local rules have the timing of when motions are filed, the timing of when things are due. And if you don't do that, then the court likely isn't going to consider those documents. So even if you had sworn affidavits, then in regard to that idea, that they weren't timely. So you had two things in regard to those issues. Finally, I want you to understand this is a temporary order idea. This is not a final decision on anything. So I want you to understand that as well. Okay. All right. So Ms. McLean, with that, go ahead.
Thank you very much, Your Honor. So may it please the court, I do represent the respondent, Tucker Sandana. And just to make sure that the record is clear, this is cause number 243-0002608. The court has already addressed the initial concerns as it related to the unsworn declarations. And I can tell the court when I was reviewing through Ms. Swindell's reply documentation, there are a number of text messages. I had difficulty understanding a time frame for many of those as they were not referenced in her declaration. The text, most of the texts themselves do not provide an actual date as to when these communications occurred. And at times it was difficult for me to understand who the communications were between. So I would just point that out and suggest that the court provide minimal to no weight as it relates to those text messages.
So I'm going to stop you for just a minute, Ms. McLean, on that. This is another thing I wanted to clarify, and I should have done it earlier. One, when people send in massive amounts of text messages, chances are we don't have time to even review all those text messages. And I don't remember how many pages there were of that, but 88 pages, I believe is what I have. We don't have time, but the other thing is that people often don't, one, give us dates. So I have no time frame. I have no time, no date, or who is even saying what. You may know when you copy it, who's saying what, but I can't look at them and just go and know. So I want you to understand that as well. Okay, if you don't give any context to what's being talked about, there's nothing I can even figure out from it. So, and when I looked at the text messages, that was pretty much what I saw. Okay, all right, Ms. McLean.
Thank you very much, Your Honor. So these folks have an 11-year marriage and they separated about 2.5 years ago. They do have 3 children born as issue of their marriage. Jada is 11, Raiden is 13, and Jackson is 15. And as you can see from the documentation submitted by my client, these parties originally had filed for dissolution in Clark County. They were both residing in Clark County at that time. At that time, they had agreed to essentially a joint custody parenting plan with the children exchanging between each home on a week-on, week-off basis. Ultimately, that action in Clark County was dismissed for want of prosecution, and both parties have subsequently relocated to Cowlitz County. Most recently, Ms. Swindell has been influencing Jackson and encouraging him to stay with her primarily, even though the original parenting plan provided for a week-on, week-off provision. But as my client outlines in his declarations and documentation, there are significant concerns within the environment from Ms. Swindell. Jackson, obviously, at 15 is a teenager, and he is going to go to the location of least resistance, or at least in this case, the area of least rules. Unfortunately, Ms. Swindell has been involving Jackson in the litigation, encouraging him to stay. And even if you did have a chance to review some of the text messages, you'll see that there have been times when she has communicated with him while he's been at his dad's house and undermined Mr. Sandana's parenting authority during his residential time. On the other hand, Ms. Swindell also is of the opinion that if the kids are getting what she perceives as passable grades, then they're allowed to skip school, which is unacceptable to my client. And she has gone so far as to encourage Jackson to quit school, obtain his GED, and has discussed smoking marijuana with him. All of these things are concerns relative to her behavior, as well as her historical presentation. Clearly, Ms. Swindell has significant questionable judgment. We see that within her parenting of the children. We see that within her own current relationship, and we see that within factors that resulted in her losing her employment as a corrections officer. As my client tells you, and you see some of this in Ms. Swindell's responsive documentation, the parties were in a fairly drawn out hearing relative to ongoing harassment by Ms. Swindell and her significant other directed towards my client and his significant other. The concern is that Ms. Swindell is currently involved in a relationship with her former inmate with whom she had an inappropriate relationship with. They do have a child together. He also has a child from a prior relationship who has been engaging in inappropriately sexually charged behavior in front of or when the children are present at their home. And this is a matter that is currently being investigated by CPS from what I understand. My client has put in the request for CPS records, but as the court knows, that takes ages to get for a private citizen. And we're hopeful that a guardian ad litem would be able to cut some red tape as far as securing those records earlier. Ms. Swindell's significant other has a very violent history. He resides in the home. And as my client has told you, there have been instances where essentially he's been acting as the heavy on Ms. Swindell's behalf in order to force compliance by my client to her whims. My client tells you in response to Ms. Swindell's bald assertion that my client has been abusive, that in fact my client has been the victim. Ms. Swindell failed a Washington State Patrol onboarding employment polygraph because she was unable to answer that she had not been involved in domestic violence. My client tells you about her circumstances where she had pulled his hair, she had beat him, tells you about an incident early on in their marriage where she pulled a knife on him, also provides a police report from 2021 where she had threatened to kill him. Couple that with her own history of mental instability, and she acknowledges that she is not currently apparently on any prescribed medication. She's not currently in treatment with any type of a counselor. She identifies in her declaration that she utilizes marijuana to control her PTSD. The concerns are that marijuana is not appropriate for individuals with PTSD. It also can counteract her depression, which clearly has led previously to suicide attempts for her and hospitalizations. There's no way to meaningfully identify how much marijuana she's using to appropriately address PTSD. And again, that's contrary to
I had a crazy idea. We were surprised that no one had done it before.
Success? Hug in a cup.
Medical recommendations. So at this juncture, we are very concerned by the environment within Ms. Swindell's household. Again, allowing the children to miss school, negatively impacting their performance. Ms. Swindell openly denigrates my client during text messages that involve the children, where she's calling him denigrating names, and as referring to my client's girlfriend in inappropriate terms. Unfortunately, even the children's medical issues have turned into a battlefield for Ms. Swindell, where she will cancel appointments and reschedule during her time. She will exert herself in an attempt to promote a false diagnosis or narratives. Even the sealed health documentation that she provides, which is from a well child check for Jackson in November of 2023, which I think is the child and adolescent clinic, although it's not on letterhead, but I believe the location CAC Longview refers to child and adolescent clinic, where even Jackson acknowledges mom is forcing him into counseling. We have none of the counseling records for the children, but clearly there are concerns as it relates to the children's environment with Ms. Swindell. We are asking that the court place all three children primarily with my client. We believe it's appropriate for there to be limited visitation. We're proposing first, third, and fifth Saturdays from 12 noon to 6 p.m. There should be a prohibition about Mr. Musso or his daughter being present during those visits. We're asking the court to restrain Ms. Swindell from using alcohol, legal or illegal substances unless prescribed by a physician, and that my client be allowed to ask for UAs, hair follicles, and the like standard provisions that are outlined in our proposed parenting plan with the loser paying. We are also asking the court to order Ms. Swindell to undergo a collateralized substance abuse evaluation and psychological evaluation with parental risk components. Obviously, it is concerning when an individual is somewhat excited about the opportunity to smoke marijuana with their children and is almost giddy about explaining that she was involved in a drug deal. Given her history, that's very concerning as far as what's going on within her household and her.
That is very
outlook
concerning.
as a parent. So we're asking the court to adopt the parenting plan that we've proposed. We do believe that it's appropriate for a guardian ad litem to be appointed in this matter. Given the Relationship difficulties between the parties. My client is also asking for the entry of a restraining order. The proposed parenting plan provides for the exchange of the children at the Kelso Police Department, but we are asking for a restraining order that my client, or that Ms. Swindell not come to my client's home, workplace, school, etc., that she not disturb his peace, and that she not threaten any type of assault or domestic violence. We believe that that's appropriate given the current status of this case. As it relates to financials, my client is employed as a supply planner with Ecolab. We have provided under seal documentation relative to his current wages and last year's wages. We're asking the court to set his net income at $5,785 per month. Ms. Swindell has not been forthcoming with regard to her income or assets. As we've indicated, Ms. Swindell has a family trust that apparently provides monies to her, as well as provides or has paid for her existing housing, which we understand she owns free and clear. She has a history of employment as a corrections officer, and it's our position that income should be imputed to her. For purposes of the child support calculations that have been submitted to the court, I've used the national median income for an individual her age, because as I sit here, I have no clue what her historical earnings have been. But obviously, as a corrections officer, that would have been significant. The basic child support calculation for the 3 children would be $951.90. We do recognize that Ms. Swindell has another child with Mr. Musso, so a deviated child support amount would provide for $796.86 per month. We're asking that the court adopt that effective March 1 of 24, and that Ms. Swindell pay her proportionate share of uninsured healthcare expenses and extracurricular activity expenses for the children. Finally, we are asking the court to allow my client to claim all 3 children as dependents on his 2023 tax return, as Ms. Swindell apparently does not currently have any taxable income. We believe it's appropriate for my client to claim all 3 children. Thank you.
Ms. McLean, you said from her declaration, what declaration are you referencing?
I'm referencing, so she did provide a cover page, and I just looked at the first and considered the first 3 pages of her declaration.
Okay.
So if you take a look at, for example,
right, and I apologize, Ms. Swindell, it would be admissible.
I'm sorry, what?
So I want to clarify on what you filed with the court. The part that would be admissible that was talked about are the first 3 pages of the 88 pages that you filed. That's your letter. So anything that's in that you can talk about. Do you know what I'm talking about?
Yeah, sorry, I'm just trying to get my bearings. So first I want to talk about how inaccurate Mr. Sandana's document was then. He lied about multiple dates on his document. We did not get married in 2010. We got married in 2009 when I was 17. We also didn't separate in 2001. And I know I can't talk about it, but there's a police report. If we can extend this, I can get it sealed and put it in, of us even fighting in 2000, before the date even says sorry, I'm so flustered. He lies about when we separated. Also, I did not get fired.
I wonder if she.
It wasn't necessary.
I wonder if she just is missing dates or if she's got other things going on. To have the dates incorrect is unlikely. The courts usually figure that out from divorce decrees, from documents. So I'm not really sure what she's saying here.
I was wondering how old she was for them to have a 15-year-old. And
Yeah.
that question, I guess, was asked. And, well, actually, she was younger.
I mean, personally, she doesn't look that old.
Then, no, well, right now, she would be 33.
Right.
Believe it or not. If I did the math correctly. No. Wait, no, I didn't do the math. Well, no, 2009 to 2019 would be 27. And then 6 years would be 33. So at the time of this case, she was 32.
Okay.
So they got married when she got pregnant, I'm assuming.
Right.
Doesn't shock me that, the poor decision making.
No.
As to, sleep with an inmate.
Yeah, true.
Now, I know some guys in jail might be kind of, hot looking. And she just made a statement.
And we don't comment on that. But
she just made a statement too that she wasn't fired, but she quit. But maybe you quit because you were going to get fired.
I mean, yeah, if you're on like your boss has already come to you twice or whatever, saying, "Oh, you can't do this again, otherwise you get fired." Guess what? You might as well just quit and call it a day.
I highly doubt that the Department of Correction said to her, "Hey, if you sleep with this inmate again, you're fired." I highly doubt that happened.
But I'm just speaking from a general point of view, guys. Okay, general point of view, general job, general stuff. Okay, don't come at me.
I mean, if that's the case, then maybe need to, peruse the prison and find a husband. Like.
If you got an excuse to find the husband in the prison, then you're like low of low.
There is a whole TV series about this. Like there's like a whole
a whole bunch of it.
Love after lockup, life after lockup. Like there's literally a whole TV show specifically based on women and men who communicate with people in prison, believe they're in a relationship. The person, when they get released from prison, get released to this person that they're in a relationship with.
True.
And I don't recall ever seeing too many successful ones, but because when they get out, especially the men,
right,
they may have told that woman everything she wanted to hear while they were locked up, but once they're out, they see that there's like a 50 million pick of the litter.
Right, exactly.
Actually, no, I take that back. There was a woman that was dating multiple incarcerated people at the same time, to even where she had different phones and different times that she would talk to them.
Wow. That's ballsy. Yeah. Ballsy.
I mean, to some extent, how can they catch you?
We don't want to know what happens in prison, but we just say it's bad. Okay?
And
just
actually,
bad.
another Love After Lockup person, she was with the guy, and they sneakily, because there was no conjugal visits allowed, so I'm not even sure how they managed this, but she had a daughter by him. And nobody knew who the father of her daughter was.
Wow.
Until she kind of revealed it, that it was the guy who was getting out of jail. Like, I think she slept with him in a broom closet kind of situation.
Wow.
So, and I believe this was in California. Just saying.
Barely to pursue a relationship, but I knew that my time in DOC had ended.
Yeah,
The
see?
way the
I
Westchester
just said
Center was
that.
ran,
You're
I
gonna
did not
quit
do it, so
because
I
you're
quit.
going to get fired.
And yeah, I did meet somebody there, and we are together in a very healthy relationship. There has been nothing negative that's come from this relationship. I would also like to point out that Mr. Sandana says that Mr. Musa was used as a heavy. Mr. Sandana had no problem leaving our children with Mr. Musa while I was in the hospital for 11 days for visitations. They had no problems correlating that. He would leave our kids with me every morning on his visitations and every evening.
I guess some of this is outside of the scope of the declaration.
It's just the three.
Am I allowed to talk about his declaration?
No.
This lady is on something.
Yep. It's wow.
Only if you responded in your declaration.
Okay.
I mean, if you agree with what he's saying, that's one thing. But if you're disputing it and you didn't dispute it in your declaration, then no.
Okay.
That makes sense.
I'm sorry, I'm trying to remember everything that was a lot in there.
You should take notes
in the first 3 pages, but there's been an escalation of behavior. It seems like every time if I play by the rules for Mr. Sandana, everything goes fine. We can co-parent just fine. And then as soon as my son doesn't want to get his hair cut and Mr. Sandana is forcing that on him and I step in for my son and he's pushing these rules, then, and that's what I talk about in my declaration is an escalation in behavior this happening. And now that I filed this with my son, my 15-year-old son, our 15-year-old son asking to live primarily with me, he's
I
now,
guess I would object as to the hearsay.
I mean, there's a lot of hearsay.
I can figure it out. Just go ahead.
I've never done any sort of drugs in my life. I am in active therapy. I see 2 different doctors. I just had a near-death experience last year, and so I'm definitely still healing from that. I'm actively in therapy. I encourage my children to be actively in therapy.
Buy
I
us
go
a
into their
river
therapy
later.
sessions.
Do what?
My oldest.
Buy us a river.
He's 15. They just butt
Buy
heads.
us a
I'm not
river.
trying to start this drama, but I do feel like when it comes to my kids, I do explode, and I'm trying not to. But when he's not letting me talk to my
Not
kids,
wrong,
and
man.
I haven't
Not
talked to him for, but there's never been any sort of like. There was when we first separated. There was the big, explosion. Then he started dating. I was dating. We were good for and then now that things just aren't going his way, now he wants to. He's had people come to my house multiple times to sign, and that's in my declaration too. To come sign divorce papers multiple times. Nothing's been filed. He has the money to do it. I don't have a trust fund that pays for my stuff. There is a trust fund, but we don't get anything from it because the park doesn't have any revenue. So if it sells, then yeah, I'll get some, but we don't have any revenue coming from that park. I haven't since 2016. So I can provide proof of that. I just need time. I don't know how to get all this stuff. I'm not an attorney. I'm sorry. And I feel like this is legal abuse. This is parental alienation because he's calling my kids into the room.
That
talking to them
explains
about
the
how dangerous I am, who all these dangerous
freak.
people I hang out with. I'm building a business with my best friend since middle school.
I'm sorry, that explains what?
I smoke a little weed.
It says here that she freaks when she loses custody
Oh yeah.
after shacking it with inmate baby daddy. But I'm guessing this is the freak. This is part of the freaking out.
And that's it.
Yeah.
And it's not even. CPS has come in because he's contacted CPS. He's had people contact CPS. They've come in. It's closed. I also provided that, but it's not. I can't talk about it.
Excuse me.
Anything else?
I guess that's all I have to say.
Ms. McLean?
She could
I don't
literally
think I have
write shit
anything further.
down.
Well,
This
that's
is
just
always
it. She
difficult
has it
when
all
one
written
party
down,
is
probably.
represented.
But she should have made
She
notes
can't
of.
talk about it
No,
for some
she
reason.
should have, because she didn't respond properly to things and didn't present proper responses to the husband's attorney.
Oh, gotcha.
That's why she was limited on what she could talk about. You can't talk about something that is not that becomes not admissible. And it wasn't admissible because she had no, I guess, it lacked authentication. Because as she said, it wasn't a sworn affidavit, which would be you're authenticating it by having it signed, notarized, that type of shit.
Right.
So that's why she's limited. But
Gotcha.
a smart person, and I guess this is probably some of my legal expertise, a smart person, a diligent person, whatever you want to call it, if you ever get like served with papers or you have to do some type of discovery, you should always map out your responses to each thing that is being presented to you.
Right.
So just like in an example, like if there's 10 things that you're being presented with, 10 things that you have to comply with or respond to, you should be creating, not just for the legal aspect of it, but for your own knowledge, should be creating a list 1 through 10 and your response to each of those items. If she
Right.
would have done that, she would have been able to have in front of her her responses to the things that she was allowed to respond to.
Right.
And the things that she wasn't allowed to respond to, she could have just ignored. Like, that's the way that you competently handle like a legal situation.
Right.
Everything is based on facts. Everything is based on exhibit. She's clearly struggling with both those things. Sorry, I had to put that input in there.
No,
And the
yeah.
other is not. I understand your frustration, and quite honestly, the court gets frustrated with not knowing necessarily the full picture. I'm not saying that against the father. It's just one thing that I would note. And as I said, the same rules apply whether you're an attorney or not. The one thing there are organizations that you can make contact with, and so that's all I can say in regard to that.
I'm on a waiting list for what?
Okay. So, as I said, we are going to move forward, and so based on the admissible files and record, the court does order the following request of the father at this time. In regard to the proposed parenting plan, let me go through that. I will adopt the 191 factors on paragraph A. On paragraph B, I will reserve.
All right, team, listen up. There's a national blood shortage. Big Ten schools, how do we
She
get
should even
students,
also,
fans,
she should
alumni-
have everything in front of her and everything written down. I don't know why she wouldn't have done that.
You would
In
think.
regard to the limitations, visitation, at least at this time, will be the first, third, and fifth Saturday of each month from 12 noon to 6 p.m., subject to the following. The father may request random observe urinalysis, hair follicle, or nail tests of the mother at any time. The father shall prepay for the testing. All testing shall be observed by the testing agency. If the mother fails to provide the requested analysis testing within 4 hours of request, said failure shall be considered a positive test, and all visitation shall be suspended pending further court order. If the mother submits to testing and said testing shows positive for illegal or non-prescribed drugs, including marijuana or alcohol, or has validity concerns, the mother's visitation shall be immediately suspended pending further court order. Failure to submit to testing a positive test result for drugs or alcohol as outlined above, or test results where validity is questioned, shall require the mother to reimburse the testing costs to the requesting parent within 7 days of the testing date. If the analysis testing is negative, the requesting party shall bear the cost of the testing. Copies of all the urine analysis testing results shall be provided to both the requesting parent and the parent tested.
That is crazy. She could lose her kids just
The
from
mother
smoking
shall be
weed.
enjoined or restrained from talking negatively or allowing third parties to talk negatively about the father to the children. The mother shall provide their current address and phone number at all times prior to their visitation. The mother shall be enjoined or restrained from being under the influence or consuming alcohol, legal or illegal drugs, except as prescribed by a treating provider. The mother shall be enjoined and restrained from allowing the minor children to have contact with Jason Musso and/or Kiana Musso or any known domestic abuser, drug user, any individual under the influence of alcohol or drugs.
Wait, did I hear that correctly? So her significant inmate and her child with inmate are not allowed around the kids?
No.
Is that what I heard though?
Inmates are not usually allowed around children.
Well, I mean, he technically lives with her, so they have a child together. She's with said inmate.
Right.
So, I'm just wondering, did I hear the judge correct?
As far as I know.
The inmate and his child are not allowed around her other 3 kids. Or do I need to rewind that a little bit? I think I need to rewind that a little bit. I'm sorry.
All the urine analysis testing results shall be provided to both the requesting parent and the parent tested. The mother shall be enjoined or restrained from talking negatively or allowing third parties to talk negatively about the father to the children. The mother shall provide their current address and phone number at all times prior to their visitation. The mother shall be enjoined or restrained from being under the influence or consuming alcohol, legal or illegal drugs, except as prescribed by a treating provider. The mother shall be enjoined and restrained from allowing minor children to have contact with Jason Musso and/or Kiana Musso or any known domestic abuser, drug user, any individual under the influence of alcohol or drugs. In regard to evaluations, the mother must be evaluated for and receive the following substance abuse evaluation. I am not going to order the psychological evaluation with parental risk components at this time. That will be reserved.
I would like to say she's been railroaded, but I mean, she set herself up for that with making poor decisions.
The evaluation shall consider input from the other parent and the guardian ad litem. Evaluation shall be completed with providers agreed upon between the parties and are approved by the court. All evaluations and participation in any recommended treatment shall be at Ashley Swindell's expense. The mother shall start or continue and comply with treatment as recommended by the evaluation. The mother shall provide a copy of the evaluation and compliance reports to the other parent and the guardian ad litem within 5 days of receipt of the same and to the court and all parties under seal. If this parent does not follow the evaluation or treatment requirements above, then 1, Failure of the mother to provide evaluations as recommended by the guardian ad litem shall be cause for the father to have visitation issues and to the mother reviewed by the court. The court shall maintain jurisdiction to ensure compliance and/or enforcement of this provision. As to decision-making, at this time, it will lie with the father. And they are listed out in the parenting plan. I'm not going to read through everything. Dispute resolution shall be by the court. Excuse me. In regard to parenting time, I've already talked about that.
She said, oh, fuck.
The children will be exchanged for parenting time at Kelso Police Department parking lot. Each parent shall pick up and/or deliver the children to the exchange location identified above, being the Kelso Police Department. The children shall transport themselves from each parent's vehicle to the other parent's vehicle. So in other words, I do not want disputes and fights and arguments at the Kelso Police Department parking lot. The children shall be picked up and returned at the designated times. Should a delay become necessary, the other parent shall be notified immediately. All transporters shall be timely in their transportation exchanges of the minor children to avoid delay of more than 15 minutes following the time of exchange. If there is an emergency, that information shall be relayed as reasonably as possible to the other parent. If the parents transport the children by automobile, then age-appropriate children's safety restraints shall be used at all times during said transportation. B, only licensed and insured drivers may transport the minor children. Failure of the parent transporting the children to provide proof of insurance shall result in a waiver of visitation until such time as appropriate documentary proof is provided. I'm not going to go through the moving with children. That's all in there. If either party moves, what that takes. And then paragraph 14, it just talks about education, information regarding the children, the exchange of that information, the communication with children, and I want both parents to make sure to read that and follow it. So with that, I'm signing off on the parenting plan.
She turned off her camera.
So Ms. Swindell, in regard to the parenting plan, I know you don't agree with it. I just need to know if you approve via Zoom.
I'm sorry, what?
So your signature is not on the parenting plan, and I know the signature does not mean that you approve of it necessarily. It's just whether or not I can put approve via Zoom because it's what I'm ordering.
So I have to say I approve it?
It's up to you.
No, I don't approve it.
Okay.
Yeah, exactly.
It don't matter if she approves it or not. It's still going to take effect.
Yep. Mother denies. Motion ordered anyway.
All right. In regard to the in regard to the restraining order,
I'm gonna have to step away from the computer. You know I can still hear what's going on.
Yeah, go ahead. Check on
If
your
there's a
food,
commercial,
too.
I apologize.
restraining order. Ms. McLean, will you be getting copies of these things to Ms. Swindell?
Yes, I will, Your Honor. Would you please, on page, excuse me, page 2, paragraph 4.
I
Mark
marked it.
Okay, and then also on page 3, paragraph 7, ask that the court indicate not required since we already previously served it and it's similar. That I will provide conformed copies of all documents to Ms. Swindell.
So Ms. Swindell, in regard to this, I have to ask you the same thing. Do you approve the assume? It doesn't mean you agree with it. It's just that it conforms to what I'm ordering. You're muted. I don't know if you know that.
Yeah, that's fine.
I always wanted to do something in the medical field. My mom's a nurse, my dad's a paramedic, and I just love having a genuine connection with people, and I think taking care of someone is a good way to build that connection.
Zach, I have no control over the.
Our faculty,
I'm so sorry.
want us to succeed.
YouTube.
The amount of opportunities in different hospitals and facilities
Is that
that they're
actually
able to get
in the
clinical
video? This is
experiences
not part of
at
the
is really
video.
cool.
She stepped away.
I can't
Give me a
wait for
second.
what's to come.
Grip, stability, precision. That's the essence of driving. Lawfin.
Did it go to?
So I'm just putting
Okay, good.
approve.
Yeah, I'm back.
The assume again, that's not to say that you agree with it, it's just that it reflects what I'm ordering. Understanding that, Ms. Swindell, do you want me to change what I put on the other one?
Yeah, please.
Okay. All right, and then in regard to child support, the court is adopting the child support worksheets, imputing at the median income based on the work history with the commencement of March 1.
Your Honor, I haven't worked since December of last year.
Well, that's a problem.
Was hospitalized and I've been at home taking care of my kids since then. I don't know what you want me to pay child support with.
Basically, I'm finding that you're voluntarily unemployed.
I'm sorry
and
about
that.
that.
You have the ability to be
That's fine.
working full-time. I have nothing to show me any differently. So it starts, I'm gonna make as April 1, not March 1.
Give her a month to find a job.
That's good.
So it doesn't go back in time if that's what you're thinking.
So did the court make that change at paragraph 11?
I will. But in regard to the child support worksheets, are you okay to again understanding what I'm ordering? Not that you're approving it, to put approved via Zoom?
Yeah.
And then I'm going to appoint a guardian.
I'm sorry, not to be funny, but so stay-at-home mom is not a defense
No.
for not having income.
Ad litem. Who do we have next on the list?
That is Sherry Evald, Beth Bellows, Karen Lawrence.
Ms. McLean, do you strike any of those?
I don't think I have any objections.
So, Ms. Swindell, basically you have a right to object to any three of these if you so choose. I know you're probably not familiar with them, but it's up to you.
Yeah, it doesn't matter to me.
Okay, so we go with the next one on the list, which is Sherry, is it Evald?
Evald.
And is it SH?
SHERI.
And
VALD.
Why are they showing an empty courtroom?
Probably just my assumption would be just like an official photo, maybe.
Yeah, but that's the courtroom here and now. It's just empty.
I don't
So
know.
this
That's a
one
good
I'm
question.
actually going to need a different order. Ms. McLean, under the application from Ms. Swindell, it states that she's indigent. That was upon filing of this matter. And so that would
Indigent.
mean I need to make her half payable by the county.
Indigent?
Is the court willing to just interlineate that on the top of page 4 under petitioner, that would be county pay? Her 50% would be county pay.
Problem is that the amounts are different.
Oh.
Maybe
Okay.
the inmate hasn't found a job yet.
Okay, so how do we handle that? Which threshold do we use then?
Got me. I don't know.
Let me go back to, I don't remember off the top of my head what the new amount is for county. So, excuse me.
So the private pay.
It's 1485.
Correct.
So, okay, so
What
the
I've seen is
50%,
that the 3,300 is for the one paying
right?
Private pay, and the 1,485 is half of that is what's.
So why don't you do 1650 instead of 15% for the respondent, and then 742.50 would be for the petitioner, $742.50, and then maybe just reference that that's county pay.
Wait, the county ain't paying her child support, are they? No.
And then
no.
Hold on.
Maybe it's for the gal, because you have to pay the guardian.
Yeah,
ad litem.
maybe.
And Ms. Swindell, I'll explain this here in a minute. And what did you say the amount for the respondent?
1650. So the 3,300 total then would be changed to $2,392.50.
So Ms. Swindell, are you there?
Yeah.
So in regard to the guardian ad litem, I determined based on the indigency for the filing that your half would be paid by the county and the respondent's half would be paid by him. So that's what those figures are all about.
Okay.
And they go at different rates, county pay versus private pay, and that's why the two different figures are being talked about.
Okay.
Okay. All right.
And then does the court want to add a reservation language for review of reimbursement once we get further discovery?
All right, I did put review of county paying petitioner's half is reserved for further review once income is known.
Okay.
Basically, the court is forcing her to go to get a job.
Yeah. Because she needs a job.
All right, so Ms.
Technically.
Swindell, again, are you okay to put approved via Zoom on this?
Yeah.
And could I inquire if Ms. Swindell has an email that she can share for that form as well for the GAL to reach out to her?
At gmail.com.
Oh, and I bleeped that out.
Swindell.
Yeah, they have to.
On our
Private.
Cowlitz County Superior Court website, there's a page for the guardian ad litems. And go to that page and you can look for Sherry Eval's name and contact information. And you can let her know that she was appointed as the guardian ad litem in your domestic case. Okay, do you know what a guardian ad litem is?
No, I don't.
Okay, guardian ad litem is somebody appointed by the court to investigate the best interest of the children and make a recommendation to the court as to what they see, as I said, the best interest of the children for visitation and schedule and that kind of thing.
Okay. I understand to a certain point, but how are they gonna know if they don't ever see the children in my care? Or will they?
Well, work that out with the guardian ad litem.
Okay.
Okay.
She'll be there on her
They're
visitation
trained.
times.
They know what they need to do. They know what they need to ask you for.
Okay.
Okay. All right. All right. So I have signed off on that order.
And then you should have a temporary order.
Okay, and then the email I'll just put in here, Ashley. You said it was 91?
Yes.
And it was at what?
Gmail.
Okay. All right, so I've signed off on that. That brings me to the temporary order, and all the temporary order really does is, there are some additional orders that I did not talk about. The petitioner will possess and use vehicles, financial accounts, and personal property in their possession now, including but not limited to the 2020 Chrysler 300 and 2005 Dodge Durango. And then the respondent will possess and use vehicles, financial accounts, and personal property in their possession now, including but not limited to the 2018 Ram Rebel 1500 and 2021 Yamaha R7. Both parties must not move, take, hide, damage, borrow against, sell, or try to sell or get rid of any property unless it is a usual business practice or to pay for basic needs. Both spouses must notify the other about any expenses that are out of the ordinary. The petitioner and respondent must each be responsible for their own future debts, including debt from credit cards, loans, security, interest, and mortgages, unless ordered differently. And then the respondent at this point, Tucker Sindana, shall be allowed to claim Jada Sindana, Raiden Sindana, Dana, and Jackson Sindana as exemptions and or tax credits for the tax year 2023. The petitioner, Ashley Swindell, shall complete, sign, and mail to Tucker Sindana IRS Form 8332, release or revocation of release of claim to exemption for child by custodial parent for the tax year 2023 as to all 3 children. Ashley Swindell shall mail the completed IRS Form 8332 to Tucker Sindana within 14 days from entry of this order with the court. Okay, that form, I believe, can be found online. I'm not quite sure. But that form you do need to get signed off and mailed to him.
And if Ms. Swindell has no objection, I can also email that to her, and we can arrange for her to electronically sign it if she would prefer.
Yeah, that's fine.
Okay, we'll get that done. Are you okay if we email you conformed copies of the orders, or do you want me to mail them to you?
Email's fine.
Okay, all right, thank you very much.
All right, and I'll just approve via Zoom. Are you okay with that?
Yeah, that's fine.
And just for the clerk's edification, the GAL appointment order sets a 30-day compliance on the GAL process of April 30th at 9 a.m.
You know,
and then
that's fine, I guess. That's spring conference.
Oh, I didn't know that.
I don't know what dockets they're going to have.
So could we set that then to May 7?
That would be fine. Let me get that back. Ms. Flindell, what I'm talking about is the judges go to a training for a few days, and so we don't have our regular dockets. So I'm going to change the date of April 30th to May 7th. So Ms. Swindell, your next court date is going to be May 7.
Recline with the highest quality standards from the footrest up. Lazy Boy, long live the lazy.
If you have SNAP or Medicaid, you may qualify for a free iPhone or Samsung, plus up to...
Okay.
At 9 a.m.
And then that also sets up the final GAL review on August 6th at 9 a.m.
Okay. All right, so those are 2 important dates to remember. But Ms. McClain will get you a copy of everything. So make sure to review it and read it carefully. Again, understand these are temporary orders. These are not final orders. And make sure to make contact with the guardian ad litem.
Yes, ma'am. Do you know when our next court hearing, will there be a chance for this to be changed, the parenting plan?
I will look at the report if the report is done and possibly consider it. Just depends on what the content is.
Okay, and then also I know it said something about a UA and there being no marijuana in it. I have smoked marijuana, so it's gonna be in there if I go to like take it today or in the next 30-45 days.
Yeah, that's understood.
Okay. So they're not gonna just like not let me see my kids if it's in there a little bit, right?
Ms. McClain?
What's your last day of use?
Today.
Okay. All right. Yeah, I'll discuss that with my client. We'll take that into consideration.
So this says it's interesting that the weed usage is prohibited at all times. It's usually just no usage near or during visitation. But I'm assuming that because there's a concern about drug use or alcohol usage.
Yeah.
Or let's be real, right? If you don't have a job,
Right.
how are you buying weed? Why are you identifying that you're smoking weed to treat something that weed doesn't treat?
Also true.
Or that the smoking weed counteracts another mental health issue that you have.
Also
Because
true.
she said that she takes it for PTSD, post-traumatic stress disorder, but it would counteract her depression.
Right.
Because it depends on the type of weed you're smoking. Like, it depends on what it depends on what effects the strain you're smoking is supposed to have, but it also depends on how your body reacts to that strain. Because
Right.
sometimes people can smoke and become super relaxed. Sometimes not.
Right.
It depends. I know people who used to get hallucinations. So doesn't seem like if she needs to be medicated, she should probably ask her psychologist to send her to a psych.
Yeah.
Obviously, that's on the record as well.
Yeah. Okay.
All right.
Okay, thank you.
Oh, maybe. Oh, they said maybe it's the dad.
For today.
All right, Swindell and Sindana, 243-000-2608.
Yes, Your Honor. Noel McLean appearing on behalf of the
And that was
respondent,
just hearing one.
Sindana.
And that was
Alright,
just
and
hearing number
Yeah,
one.
that was. Yeah, it was almost an hour. Like, but now we get to see who the dad is.
Right.
And the gal.
Looks like, and we have Ashley Swindell present.
Yeah, I'm present, Your Honor.
All right, thank you very much. Every once in a while I review my notes and they don't make sense to me, and so I just have to
Oh,
look
we
at
got our
something
other judge
before,
back
and then it
finally.
usually comes back. So just give me 1 second. So it looks like there's a motion. The contempt motion isn't on today. Today is the motion for temporary family law order, correct?
Yes.
And that was filed by Ms. Swindell, and it looks like there is a new proposed parenting plan being requested for those 3 children. And right, and I reviewed, for the record, I've reviewed that motion, the declaration in support, the proposed parenting plan, and then
Looks like Judge Fassett, but
the reply declaration.
She must be in the other woman's room or something.
Yeah.
Using her Zoom.
The reply declaration. I'm weeding through here to make sure that I'm not conflating the contempt motions with or contempt responses with the responses to the parenting plan. So Ms. Swindell, go ahead. It is your motion.
Thank you, Your Honor. First, I wanted to emphasize to the court that I have been the primary parent for all of the children up until March 19th, the last court date, and that Mr. Sindana had no issues with our children being around me, my partner, or my partner's child until I filed for full custody of Jackson, which would have required him to pay child support. The sudden shift in this stance shows his intentions are financially motivated rather than focused on the children's well-being. Despite having the ability for years, Mr. Sandana has never put our children on medical insurance. They have only had state medical coverage or the medical insurance provided by me through my
Your Honor,
work.
I guess I'm going to object at this point, as this exceeds the documentation that I received. And I note at the top of this motion, Your Honor indicated you reviewed a declaration. I've not received a declaration for this motion. I received a motion for temporary orders, an information regarding a temporary parenting plan, a proposed parenting plan. And then subsequently, we had received a proposed temporary family law order, child support worksheets, child support order, and the docket notice and a summons to modify the child support.
Yeah, I didn't receive any of the child support information, so I don't have that, and I don't see that as part of her initial motion. So I don't have any of that before me, so child support is not something that will be discussed today. And I will clarify, in Odyssey, it is listed as Index 53. It says Declaration in Support of a Parenting Plan. When you look at that, that's the information for a temporary parenting plan. So I don't know if that was entered in correctly, or because it's not a declaration. As we think of declaration, it is the information for a temporary parenting plan.
Right. So given that, I would object to the argument that exceeds the scope of her declaration.
And I'll sustain that. So Ms. Swindell, you need to keep your argument to the information that's been provided to the court and the other party.
Yes, Your Honor. Yes, Your Honor. Okay. So our oldest son has been grounded for over 2 months, which I believe I've put in the letter that I've given to the court and to Ms. Noel. He's been grounded for communicating with me about issues that are going on in the house. My middle son,
I'm sorry, but again, I'm going to object because this is new information that should have been included in her initial declaration so that my client could have had an opportunity to respond. I saw that documentation that was filed this last week as being responsive to the pending contempt motion.
I don't see, Ms. Swindell, anything in your motion for temporary order or your declaration in support of a parenting plan that indicates that anybody has been grounded for 2 months for talking to you. I understand that you're alleging that there's parental alienation. So I understand that, and I don't know if that's
partly due to the.
All right, go ahead.
The alienation that I'm referring to is part of the lack of communication that he's been imposing on our children. If they communicate with me about anything that's going on in the house, he will remove their cell phones from them and tell them that they're inappropriate for contacting me about issues. And it's been going on now for 2 months with our oldest.
Again, I would object at this point due to the hearsay.
All right, so here's my concern. There's a couple of different things that I'm just going to put out here right now. So the parenting plan, the last court date was in mid to late March, where Judge Hahn entered an order appointing a guardian ad litem. She entered a temporary family law order, a child support worksheet, and a temporary parenting plan. Does everybody agree about that?
Yes.
And that temporary parenting plan was, I'm looking at it right now, has Judge Hahn's lining out a whole bunch of different areas, striking certain areas, reserving on certain areas, and clearly Judge Hahn made the determination on this temporary parenting plan. We can all.
What happened?
It sounds like there's a lot going on. Just, striking of records, so on and so forth. A lot of just hearsay information in this case so far.
I don't know what her what she's hoping to gain from her motion, other than to I'm assuming, tried to go on the attack after.
Right.
She basically didn't like that temporary order. She didn't like the temporary parenting plan.
Right.
So
it sounded like she didn't like the, yeah.
So I'm thinking that this is her way of, trying to have things go in her favor.
Right. I think that she's trying to just, I don't know, trying to, present new information somehow. I don't understand.
Yeah, but the attorney is not going to allow that if
No,
it's not.
apparently.
If there's no well, she said it wasn't in, I guess, whatever the response or whatever they got.
Right.
And you have to give the other party time or opportunity to respond to your allegation.
Exactly.
Which it looks like she didn't do.
Right. So.
Agree on that, I believe. I understand that there is a motion. This is a little bit unusual for within 2 months to have a motion for a new parenting plan entered. There wasn't a motion for reconsideration of Judge Hahn's ruling. But if you're asking for a completely different parenting plan than the one that Judge Hahn just entered 2 months ago, I think it's most appropriate to be heard by Judge Hahn, since there's clearly a reason why she entered the parenting plan that she previously entered.
He is not happy about that.
All the parties that did not, and I know that there's a GAL on board now, so that could be additionally helpful, but I did not review anything.
I'm sorry, if I'm not mistaken, the judge specifically told her the dates of the next hearings and, told her that it is temporary, but she did not tell her, if you don't like this plan, you can ask for it to be revisited that quickly. They were not even supposed to have a GAL report. She said something about if there was a report by the next hearing, I think. Or she said something about a hearing being in the summer.
Right, something like that. I can't remember.
Once the GAL has, done their findings or whatever. So she's basically trying to circumvent all of that.
Right.
And have it just change. But honestly, the judge made those decisions based on what was presented.
Already.
So another judge is not going to change. Another judge is going to most likely come to the same conclusion.
Right.
Nice try, though, lady.
Right.
Prior to that temporary parenting plan being in place, so I don't have any background as to why that order was entered the way that it was ordered. So clearly, Ms. Swindell, you have some concerns with that. I can understand that and sympathize with that. I'm assuming you've been working with the GAL since they were appointed 2 months ago. Is that correct?
Yes, Your Honor.
Right. What I'm inclined to do, and I don't know if the parties are available on either July 2nd or July 9th, but I think this is most appropriately heard by Judge Hahn, since she literally just entered a temporary parenting plan in this case.
Your Honor, the contempt motion is scheduled to be heard on July 2.
Is everyone available on July 2nd?
Yes.
Yes, Your Honor.
All right. So I'm going to set this over 2 weeks to July 2nd, 2024 at 9:00 a.m. for Judge Hahn to hear the merits of the request for a new parenting plan.
Thank you.
So everything at this point will remain as is, and we'll come back in 2 weeks, and you can make your arguments before Judge Hahn.
All right, thank you.
And now we know why the hearings are shorter.
What matter is that?
Right.
Your Honor, if we may call Swindle and Sandana,
Hearing
I'm
number
not sure if
3.
child support is being addressed today, so I just wanted to confirm if that's being done or not.
I'm sorry, what is the name?
Swindle and Sandana.
Okay.
On my docket, it's 15 and 16.
24-3-00026-08.
Noel McLean appearing on behalf of the respondent, Tucker Sandana.
Do we have Ashley Swindell?
Yes, Your Honor, I'm here.
Okay, thank you. Be just a second here.
He was there in the last hearing.
And I apologize, Ms. Looney, you were indicating what now?
Well, Your Honor, when we were here last, Ms. McLean had indicated she'd been served with a proposed
hiding?
order and worksheets.
Yeah, I wonder.
And that at that
Gee, I
time,
wonder.
Judge Fassett was
They must have
presiding and
missed
said
it.
that those were
You
not
did.
available to the court. The state has not received copies of that either, and I don't know if the court has.
Although
them at this point.
I didn't see much more of those like pop-ups like that
I had
lately.
received a motion from Ms.
Yeah, 'cause nothing
Swindell,
happened.
Which is a motion for, I think it's number 13 on your docket. Ms. Swindell had filed a motion asking this court to modify the temporary orders by changing the parenting plan and the child support order. And we've objected to that, but
Do you know when that was filed?
I received it on May 23rd. It looks like it was filed on May 17th with the court.
Okay.
And so some of the difficulties that we're having is that Ms. Swindell will serve my office, have hand delivered to my office, or email us certain documents, but they tend to be different than what's filed with the court. So I had received I think it was a hand delivery, or no, it's an email delivery that included a proposed child support order. But I don't know I don't see where that's actually been filed with the court, just a proposed parenting plan, it looks like.
So when I went to go put them into the courts, they told me to contact child support. I have not been able to do that, and they didn't take those forms, and I had already scanned that all in and accidentally sent it to you.
Ever wish you had a power-up for the ACT?
I don't know if I buy that.
All right, so
Maybe an attempt was made, but
the two
no.
things that I know are on was the contempt and the mother's motion. So are you saying, Ms. McLean, bottom line is you don't have the same documents that have been filed? Is that what I'm understanding?
I have more documents so I do have a proposed child support order and worksheets from Ms. Swindell. She did not serve the state, and apparently the clerk's office did not accept those documents, but I have received them. I don't know if the court has proposed orders from her that include the child support order. She's asking to modify the parenting plan to change custody back to her. She's asking to modify child.
Is anyone shocked at
Those are
trying to
based on
have
her motion
custody
that
returned to
should have been
her?
filed
I didn't
on May
see the
7th.
bottom
Sorry.
line.
All right,
Sorry,
so
I went back. It went by so
the two
quick.
things that I know are on was the contempt and the mother's motion. So are you saying, Ms. McLean, bottom line is you don't have the same documents that have been filed? Is that what I'm understanding?
I have more documents so I do have a proposed child support order and worksheets from Ms. Swindell. She did not serve the state, and apparently the clerk's office did not accept those documents, but I have received them. I don't know if the court has proposed orders from her that include the child support order. She's asking to modify the parenting plan to change custody back to her. She's asking to modify child.
The bottom line
Is
says
anyone-
she's about lost it when dad was giving primary custody.
Well, is anyone shocked she's trying to have custody returned?
No.
Okay.
No.
And those are based on her motion that appears to have been filed on May 17th.
So what I have is in regard to the parenting plan, but I do not see anything as to child support. And maybe I'm missing, sometimes it's hard to tell from all the documents and what is what, but I don't recall seeing any child support. And you're telling me, Ms. Swindell, that they didn't accept those documents, is that correct?
Yeah, that's correct. They referred me or they told me to go contact the child support people.
All right, so Ms. Looney, sounds like you have not been contacted yet.
We have not, Your Honor.
Okay. All right, so let's just start with that matter then. If the child support is not in here, the state has not been contacted, then it doesn't make any sense to proceed forward with that particular matter. Ms. Swindell, would you agree, since I don't have everything?
Yes, Your Honor.
Okay, all right.
And I would simply ask that the court reserve my client's request for attorney's fees, because technically this is the second time we've been here on this motion. We were in front of Judge Bassett on this motion on June 18th, which was set over to today's date. So I would just ask to reserve fees.
That would be reserved. Ms. Swindell, please reach out to Ms. Looney in regard to child support and get those served on their office of what you're proposing and your contact information. Ms. Looney, anything else that you need?
Your Honor, I can give her our physical address where she can drop off copies of her documents.
Okay.
All right, as this case
You can bring
ends,
them to
I'm actually going to take a
1338
quick break, folks.
Commerce
I will
Avenue.
be back momentarily. All right.
Welcome back.
Oop, wrong screen. My bad. My bad. Wrong setting. All right.
Suite 305 in Longview.
Thank you.
All right, so let's go ahead and address the contempt matter.
Yes, Your Honor.
Does anyone want to make a prediction on what the contempt is for? I'm assuming it's against mom. I think it was the contempt from the last hearing. I think this was a continuation of that contempt.
I don't actually know.
Well, this is hearing 3.
Right.
In hearing 2, she brought the contempt, and but his attorney did not receive it. And then she wanted to also do the change of the parenting plan and stuff.
True.
So I don't know if this contempt is that, or if it is a new one. So I guess we're gonna find that out.
So as I indicated, I do represent the respondent, Checker Sundana. We are asking the court to enter a finding of contempt against Ms. Swindell for violating the parenting plan as well as the restraining order. Your Honor entered the temporary parenting plan and restraining orders in this case on March 19th, so earlier this year. Our position is that Ms. Swindell has violated paragraph 4A1 related to the visitation. She's violated paragraph 4A 2D as in dog, related to not consuming illegal or legal substances without a prescription from her provider, and violating paragraph 4B1 for not obtaining a collateralized substance abuse evaluation. As can be seen from our sealed health documentation, Ms. Swindell tested positive for marijuana on May 3rd. Actually, she had submitted one on May 3rd of 2024. I'm sorry, she had submitted one subsequent to that. We waited 7 weeks from her last use, and so on a UA, her system should have been clean within 30 days. And yet the sample was nearly 5 times the cutoff limit. And not only that, she tampered with the testing because it shows that it was dilute. It is clear, even from her responses, that she's not stopped using marijuana, and now she's trying to suggest that she needs to be prescribed marijuana by going to a facility that's going to issue her a prescription just for the payment.
While I don't usually think weed is a big deal for adult use, clearly she's unable to stop despite a court order. I guess that says it all, right?
Right.
If you can't even stop something that's not, well, is weed addictive? I don't think weed is addictive. I've smoked.
I do. I think it's really addictive. Sorry for being loud, but yeah, I do, because that's yeah.
I'm gonna have to disagree with you simply because I've smoked weed over the course of 20 years on different occasions, and every time I have smoked, I have not had a desire necessarily to smoke again. Like, I might have it the one time and then that's it, or like I could even say the last time that I had smoked any weed had to have been like a year ago.
Right.
Now, full transparency, I am a cigarette smoker, which is addictive. So I would rather have a cigarette than have weed.
Right.
But I've also still for me, weed is not addictive.
I think that
smoke it every day.
I think that it can be addictive depending on,
It depends on the person,
user.
and it depends on the user, and it depends on their reliance for whatever whatever they feel when they smoke.
Now, we're not dismissing.
I do know people.
We are not dismissing anybody that has it on a medical card, anything like that, or commenting that you shouldn't even do it.
I don't even see. I mean, as far as I'm concerned, in my state is legal. So,
It's legal here
I
too,
mean,
is
to me,
in California.
it doesn't
So
matter. It doesn't matter that you're smoking it,
Right.
but
we're just
because
getting a general opinion.
I know people who smoke daily.
Right.
I know professionals who
Yep.
smoke recreationally.
Right.
And even before weed was legal,
Right.
I worked for 2 attorneys who were potheads. So
How about they do their cases?
like,
Oh, wait. See, that's where I disagree to a certain point. I believe that, weed does impact how you do things, though, in my opinion.
weed makes me horny. That's kind of why,
That's a lot of information out there for the world to know.
Yeah, but that's
yeah.
But that was my first, like, my body's initial reaction when I first tried it. Now, 20-something years later, that's not exactly the same. But weed has changed in 20 years.
Right.
There's different strands that have different purposes.
True. I mean,
think
yeah,
the last thing that
there's
my aunt gave me, the last thing that my aunt gave me, and the edibles that she's, talked me into eating,
right.
For me, I feel have had no effect on me at all. So, I mean, those things do depend, but something tells me that him not wanting the drug use is maybe because he doesn't want it done around his kids, because he doesn't do it around his kids. Another thing may be, how about that you have, okay, we don't know if her her inmate baby daddy is a felon,
right?
But 9 times out of 10 he is. So
yeah,
should
we would assume
drugs
so.
In the household?
I'm just gonna say the word assume lightly.
Well, she was a correctional officer, and I don't think they have correctional officers in like in a jail, like a police jail, where they hold people, right?
Right.
It would most likely be prison, not like a county jail. I don't know. Okay, that I'm not 100% sure. I don't know much about correctional officers, other than they look really nice in their uniforms. But what they do, I'm telling you, a man could be ugly.
She likes people in uniforms.
A guy can be ugly, but you put on a uniform and he looks like an Adonis. I mean, I mean, court officers too. Like court officers, some of them be looking kind of nice too in their little court officer uniforms. I'm just saying. It's the same thing for military.
Thank you, bud.
And police uniforms too. Police uniforms sometimes. It depends. It does depend on those. There's nothing really sexy about a cop, to be honest.
Right.
But this is strange. But the fact that she couldn't stop smoking means that there's a problem. And then they said that she diluted her urine. Really? It doesn't work that way, lady. The water doesn't help you.
Nope.
Oh. And she did maybe that's why she tried to have her parenting plan changed, because she'd be in violation of the current parenting plan.
Right.
Because, yeah, see, she was being sneaky. That is, she tried it.
Mm-hmm.
She tried it. Mm-hmm. She knew she was gonna lose. She knew she was gonna lose her visitation.
Mm-hmm.
If she came back positive, because she even said, "Hey, I smoked today."
Right.
So will it not count if I have to do the test right away? But they waited almost 2 months, so that means you just kept smoking. And the whole thing is too, those drug tests can be random.
Yep.
So you can't even have in your mind, oh well, I could smoke up until this day. No, it doesn't work that way, lady. How about you wait for them to drug test you, and then you smoke after the drug test? Smoke once above. Because you don't know when he's gonna do it. Actually, though, if the father was smart, he'd do like back to back, and just suffer the cost of it just to catch her up.
The parenting plan provides, again, that she's not to use any substances, and we specifically waited to ensure that those would have cleared her system. But again, she continues to use in violation of the court order that prohibits that use. The parenting plan, as a result of that, has terminated her visitation and contact with the children. And I would also note that the restraining order also entered back in March, prohibited her from going to the school or coming within 500 feet of the children's school. The parenting plan also prohibits her from allowing the children to have contact with her significant Jason Musso. And so what you see from the original motion is that she went to the school, she dropped off a birthday gift for Jada. We provided proof of the gift and the cards that were delivered on May 17th. And then a second time, she sends her significant other, Jason, to the school to deliver documentation for the children. Simply inappropriate, in violation of the court orders, and in violation of the fact that she's not supposed to be having any contact with these children. It is clear as well that she has not complied with the court's order to participate in a collateralized substance abuse evaluation. The assessment that she provides is a one-page statement from Cowlitz Family Health Center. It does not include the information as far as any UAs that may have been collected at that time or what the results of those UAs are. It also is silent as to any collateral contact related to my client, and he tells you specifically in his declaration that he's not been contacted to provide collateral input for a substance abuse evaluation involving Ms. Swindell. And as far as we know, the guardian ad litem has not been contacted to provide that collateral information. There is no valid prescription for marijuana, and quite frankly, the suggestion that smoking marijuana is an approved method of administration for THC, there's no way to measure how much THC is being ingested. And obviously, marijuana was a concern with this court and Ms. Swindell's parenting, and she's simply attempting to try and legitimize her addiction. So we're asking that the court enter findings of contempt for willfully violating the provisions of the restraining order and the parenting plan. We're asking the court to order her to comply with the evaluation process. She should be required to do that within the next 30 days. We're asking the court to enter sanctions of $100 and attorney's fees of $1,500. And that in order to purge contempt, that she is to comply with all court orders. She's not to attend the children's school or contact the children directly or through third parties unless ordered by the court. Again, participate in that collateralized substance abuse evaluation within 30 days and to pay the judgments within 90 days from entry of the order with the court. And I have provided the court a proposed contempt hearing order.
Ms. Swindell?
Good morning, Your Honor. So I've been pretty open with my use of marijuana. I'm open with my doctors. I'm open with my therapist. Yes, I never went and got the medical marijuana card because there is a fee to it, and I just didn't feel like it's legal. So it's state legal. So I didn't feel like going and getting one until this happened. And then when he started using it against me, I went and was getting a legal marijuana card because he's known about my use of marijuana because him and I both smoked marijuana together when we were together. So my doctors are very aware of my use of marijuana. My therapists are aware. He was aware, and I just wanted. So I did fail that UA. I have been a daily marijuana smoker for over 5 years. It stores in your fat cells. So if you are just a just smoking marijuana a little bit, then yeah, it'll be out of your system in 30 days. If you are like smoke daily.
And I guess I would object as to her testifying as an expert. There's no qualifications that she has sufficient education or knowledge.
Have you tried XLOOKUP?
You tried it though.
To be identifying how quickly marijuana metabolizes.
So the court understands that and understands what is acceptable and what isn't. We'll give it the weight that it deserves. Go ahead, Ms. Tyrell.
I also want to bring up that Mr. Sindana had no problem with me smoking marijuana until I filed for full custody of our oldest son because he was having anxiety issues, and him and his father butt heads quite frequently. I've been trying to keep it very fair. I've been trying to avoid this entire time. I'm trying to do everything right. I do have the UA from the eval that I did that shows marijuana and nothing else. I passed a UA for my job that showed marijuana and nothing else. I did a hair follicle test that showed marijuana and nothing else. But yet Mr. Sindana, when beginning this case, had his attorney try to make it sound like I had substance issues that were bigger than just marijuana. And that's what led to this. He's been frequently exaggerating things, just like our last court that he tried to get a restraining order on my boyfriend, and his girlfriend tried to get one on me and on my boyfriend too. It was on November 7th of 2023. I have the number of it. It was thrown out because it was so exaggerated. They have been keeping me from seeing the kids. The moment the court issued the documents of the no contact order, he went to their school, he went to their doctors, he went to their therapist with a copy of it saying that I am not to be contacted for anything. And it clearly states in the parenting plan that I should be on there before any other, me and him only. And I still should have contact with schools, even though I cannot be at the school. I didn't go to the school. I had my boyfriend drop something off. He did not talk to the kids. He dropped it off in the office because his daughter goes to the school right next to it. He dropped it off in the office. He dropped off a birthday card from me and my uncle. That was it. Nobody talked to the kids. Nobody seen the kids. I did not go to their school, but they're exaggerating. Again, this is a habitual thing. He's using the legal system. He's using, and this is just, it's getting to be so much that he's now trying to record.
The order said not to do third party.
Without my permission. Or the children's knowledge. It's getting crazy. And I understand that we have until we've been assigned a GAL and she's done her investigation, but it's not due for another couple weeks. But I really think that the court will see how much this is getting exaggerated and how much this is ridiculous. I can't afford an attorney. I'm trying to work and pay child support, raise a toddler myself. This is crazy. And I guess that's all I really have to say.
Ms. McLean?
Well, obviously,
it looks like a lot of your bad judgment led to this situation popped up across the
She
screen.
acknowledges that she sent Mr. Musso to the school in violation of the restraining order and in violation of the temporary parenting plan, which specifically states at paragraph 4, A, Q, E, the mother shall be enjoined and restrained from allowing the minor children to have contact with Jason Musso and or Kiana Musso or any known domestic abuser, drug user, or individual under the influence of alcohol or drugs.
Objection?
Her choice.
Can I say something?
What's your objection?
They didn't have any contact. There was no contact made. So I don't understand this.
Okay. You've had your turn. So let me hear from Ms. McLean.
The violation wasn't even being at the school.
Right.
To have any contact with the children to the school to deliver items.
That's,
and again,
yep.
the restraining order prohibits her from coming within 500 feet of the school. There's absolutely no evidence before this court that my client has prohibited her from having contact by phone or email with providers. There's no evidence of that. It is accurate that the providers have been provided the restraining order to make sure that they're aware that she's not supposed to come within 500 feet of those facilities. And yet she's violated. So we're asking the court to grant the relief as requested.
Next house.
I've reviewed the files and record, heard the argument here today, and the court does find that Ms. Swindell has intentionally, maliciously and intentionally violated the court order, restraining her from going to the school. Whether it's directly or indirectly, Ms. Swindell, that still meets the requirement of not having contact or going to the school. So if you send somebody with something to the school to give to a child, that's no different than if you're standing there and give it to the child. So also in contempt, as well as consuming marijuana and not obtaining the evaluation that was ordered. It is irrelevant as to the motion as to whether or not the respondent has smoked for purposes of this motion. You can purge a contempt by coming in compliance with the court order, including obtaining the ordered evaluation within 30 days and comply with the court order. You will be required to pay a $100 sanction and $1,000 in attorney's fees within 90 days of entry of this order.
Contempt. These are the contempt fees she was required to pay. If you could read that, that'd be awesome.
Okay, so it was on July 2nd, 24. That's the date it became effective. It's still active.
Ouch.
The attorney's fee was $1,000, 12% interest.
Ouch.
Interest start date is October 3rd, so they don't even start it right away.
Ow.
And then there's an other fees, which is $100, interest at 12%. Also, to start date was for the interest is October 3rd, and the total is $1,100. But according to this, like it's still active, so it's not. Maybe we'll see later on if she ever pays it. I guess.
Right.
Because we're only on hearing 3, and we still have like I think 4 more to go.
You've been told no marijuana, no smoking, no having it, and yet you continue to do it. Whether you think that's okay or not, you're going to continue to follow through, or you're going to continue to have contempt motions brought, I'm sure. But it also weighs heavily on whether or not you're willing to follow a court order. And from what I can see, you are not. So with that, I will be signing off on the order.
So the court will need to make changes at paragraph 1 and 8 to reference the $1,000 in attorney's fees. And I will provide Ms. Swindell, Ms. Looney, and Ms. Evald with conformed copies of the orders once they're available on Odyssey.
I've made those changes. Ms. Swindell, are you okay to put approved via Zoom?
Yeah. Yes, Your Honor.
The only other thing that I would ask is if the court is willing to add in the language at paragraph 13 about reserving respondents' request for attorney's fees relative to petitioner's motion to modify.
You can just bring that up if it's back again.
Okay, I'll just reference the clerk's notes then. Thank you very much, Martin.
Crossover.
Okay.
Mom got pulverized by the attorney. Her emotional argument has no weight in court.
I have the one order that
that's the order that I had proposed, assuming the court denied Ms. Swindell's motion to modify the parenting plan.
Okay. All right.
So you can round that out.
All right. Thank you.
Thanks.
Next, I have Ashley Swindell and Tucker Sandana. And there we have
different
Ms.
judge.
McLean is representing Tucker Sandana. And Ms. McLean
Your
is
Honor.
present. I see her.
I wonder if we're going to
And
finally get a
see
gal
Ms.
report.
Swindell is on the line. Is
Right.
it Swindell or Swindell?
I was wondering about that.
Swindell, thank you. Both are present.
I really
and,
wish that
we
when
think
other
we're-
people's
and-
cases were like over, that they would just leave and not wait to hear what's gonna be.
Right.
Because it's, or like I said before, like just turn off your camera.
Right.
Because it's so distracting to see faces that don't belong.
Right.
Though this is a couple, so maybe I don't know.
And Ms. McLean, is your client, Mr. Sandana, on the line?
I saw him earlier.
Yes, I'm on the line.
Great, thank you for confirming that. Appreciate that. All right.
It
So we're
looks like
on
Ms.
the-
Evald is also present, the guardian ad litem.
Great, thank you. So we have.
Excuse me.
Today's, it was docketed for the final GAL report, and when I checked yesterday, I didn't see that it had been admitted. Has it been filed, or is it still in process?
We've received it by email. I understood that Ms. Evald filed it. I can't remember which day, if it was last week or.
Oh, okay.
That is correct, Your Honor. That was filed last week at the courthouse.
Okay.
So I've received it.
Okay. Interesting. I think what happened, and I apologize for this. I knew my week was going to be full this week, so I started prepping over the weekend.
Oops.
But even then, it was filed on the 2nd.
What is this hearing for?
In full
The
transparency,
GAL
I didn't read
report.
it. I had noted in my notes here, said no filing of the final GAL.
And it's not there.
Strength training.
Okay, GAL, you're slacking.
Gym Monster 2 is an
You're
all-in-one
slacking.
design that
And I just assumed, I didn't remember that that Judge Hahn wasn't going to be here today. She
It
wanted
was
to see
filed,
the
but it was
case
filed,
markers.
I think, late.
And we would be following up with any motions if either of the parties desire to do so. So that was just sort of my anticipation.
Okay. Ms. Swindell, do you have any input?
I mean, I don't really know what's going on. I'm sorry.
Yeah, that's fine. So Ms. Evald has finished her report, and it's been submitted. And then generally, from what Ms. McLean is indicating, that typically Judge Hahn will then await for parties to file some type of motion based on the information that's in the guardian ad litem report. So that's kind of that would be the next step. So today basically is kind of a marker that the report's been filed. Great, thank you, Ms. Evald. And then if either party feels so inclined, then you could bring a motion asking for some type of relief from the court based on that information that's in the report.
Okay, so I need to file a motion then?
If you're so inclined,
There's no motion. We won't hear about what's in the report until there is one. Aw.
that would be the next step.
Bummer.
Okay, thank you.
But
And then anything else?
I
Ms.
don't
McLean?
doubt there will be a
No, thank
motion
you.
very soon.
Okay, great. We'll conclude that, and we'll allow the parties to move
Right.
forward as they.
And remember, this is when she loses custody after.
Give me a second. I need to bump a light. I'll be right back, folks.
You need a what? Well, what?
I need to go bump the light. I can't see anything.
Okay, bump it. Bump it real good.
Sorry, I had to go across the room. Sorry, guys. Go ahead.
Okay, so what I was saying was that she freaks when she loses custody.
What?
So I'm wondering if there's still a drug problem or whatever.
Have Sherry Evald? Yes. Do we have Ashley Swindell?
Yes, Your Honor.
Okay. All right.
So what do you think filed this motion, Mom?
let's go first to the guard item report.
Probably the mom.
I think so.
The report that I have was filed on August 2nd.
And I've received a copy of the report. I would note that I had also requested a copy of Ms. Evald's file. She has not provided the counseling records for the parties or the children, or the medical records for the children. I'm assuming that we need a court order for her to release those. Since I'm representing a party, I'd like to have access to those since it's a matter, I'm assuming it's going to have to move forward to trial, or first, I guess we need to do a settlement.
Ms. Swindell, any objections to that?
I don't think so, but I don't understand, sorry.
Want to restate your request, Ms. McLean?
That the court order that Ms. Evald is to release the copy of the children's and the parties' medical and counseling records that she reviewed for purposes of her investigation and the report that she submitted to the court.
Oh, yeah.
Okay. All right. So with that, that request will be granted. Ms. Evald, you'll have to provide that information.
And I'll prepare a subsequent order to that effect so that she.
Why didn't she provide this shit before?
Okay.
Right.
Just wasting people's time. Shit.
Anything else? I do not have a motion, which I typically will require before I adopt or make any changes based on a report.
And that was one of that would be one of my initial objections, is that there is no motion before the court. I would also object to the unsworn items that are identified as evidence that were filed by Ms. Swindell. Those are clerk's papers 82 and 87. And then I would also object to the basically the sealed personal health care that's clerk's paper 88 because there's no.
Hold on, let's go through these one at a time.
Sure.
So looking at number 82, it looks like they are text messages.
Yes, but there's also boxes of basically what appears to be a declaration. If you look at the top of the first 2 pages.
I believe they're just explaining what's in the pictures.
Okay. So, Ms. Swindell, when you are filing anything that's a statement, it has to be a sworn statement.
Which they told her last time.
And if it's not, so I understand you're just explaining the pictures, but if it's not a sworn statement of what's being seen, then it can't be considered by the court. Okay? So,
Can you just look at the pictures and just like not read the top?
Well, I would agree with Ms. McLean. It appears to be a form of an affidavit or a declaration. So you're going to have to either comply with that requirement or it won't be considered. Okay?
He was already warned about that from the first hearing.
Right, she was already told.
Basically the same objection as to number 87, clerk's paper 87, that's again identified with the title page of evidence.
Okay. So this is similar, Ms. Swindell. Same idea. You'll need that sworn affidavit. Okay.
Yes, ma'am.
As it relates to clerk's paper 88, which is a sealed personal health care record, I have no idea who this is from. I don't know as far as what provider this came from. There's nothing that tells me, the name of the facility or the address. So I'm concerned about that. that I don't have those types of identifiers.
What was this?
This is your sealed personal health care records.
Oh, for Jackson?
That's part of the problem, is it doesn't give the detail that
her camera
would
fell.
be necessary to identify who the provider is
Happens.
and who it's even having to do with.
Good thing she had pants
You know,
on.
but you can't
Good
tell from
thing.
just looking at what's in the file. Okay?
Okay.
So again, the court will not be considering it until it has the correct personal identifiers. Ms. McLean?
The other issue that we've had is that consistently Ms. Swindell will either not serve my office or serve my office with items that don't correlate with ultimately what she files with the court. For example, I was served with a docket notice for August 20th, but she filed a docket notice for August 27th. We only found that because it was on Odyssey. And so my concern is that consistently I'm not being served with the correct or the same documentation and information that she's filing, or I'm not served at times at all. So I don't, this has been an ongoing issue. I guess the only other potential would be for the court to say that there has to be court approval before she files, with verification that she served me the actual stuff that's been filed. I don't know how to rectify that. But this is not the first time we've had this discussion. This has been an ongoing and consistent problem.
So the court's not going to order court review at this time. Ms. Swindell, you have to understand, anything you file with the court, Ms. McLean has a right to a copy of exactly what you file.
I am sorry that happened. What it was a typo, and I rectified it in the following email. What she's trying to get thrown out is the proof that I rectified it in the following email. So she's manipulating and lying.
So
I'll refile that to prove that she's manipulating and lying, but.
So you have to do
She's
that,
smiling.
or it won't be considered, bottom line.
Okay.
Okay. So these are legal questions that you can always consult with Cowlitz Wahkiakum Legal Aid. They come, I think, on Mondays, or Northwest Justice Project. Those are the two possibilities that are here locally. All right. So with that, this is in regard to the guardian ad litem report and the parenting plan. Again, I take a motion. I will not make changes without that motion, except in some exceptions to that. That report was filed. With that, anything further at this time?
I have submitted a proposed order to the court. We are asking for the court to award my client $750 in attorney's fees for having to be here. It's not proper. Technically, she did not provide correct notice, and then it wasn't timely notice, which meant that we had to engage in additional communications with all the parties involved and the clerk's office in order to set this matter over. So that I could have appropriate time for my client to respond. And of course, my client has responded, which again is time and effort, which means he's expended attorney's fees. I would submit that even if you look at the sufficiency of the information, there's been no showing of a substantial change in circumstances since the last time we were before the court in regards to contempt. So we're asking the court to adopt the order that I've presented to the court and award my client the fees.
Ms. Swindell?
She is not a happy
This
camper.
was because I assumed the court would read, the GAL report and understand what's happening here and do something about it. This is the second court hearing we've had for the GAL report. The first time it wasn't read. the second time, apparently it does not matter. And this is sad. This is very sad.
But based on the files and record, I will grant the request and sign off on the order. Ms. Swindell, have you seen a copy of the order or not?
Yeah, I saw it.
All right, understanding that's the court's ruling, whether you agree with it or not. Are you okay if I put approved via Zoom?
Yep. Yes, Your Honor.
All she had to do was comply. There was not much
We will
like.
provide a confirmed copy of the order that the court has signed. And I guess my question for you is, would you be opposed to just interlineating at 6D that the guardian ad litem shall disclose? Or do you want me to go ahead and submit a subsequent order?
I would rather you go ahead and do a separate order and then just put not approved for Ashley Swindell's signature and then the date.
I just provide it ex parte.
As long as you put on there, send it to my attention and
Okay.
just put that, as she said, she's not approving it. So just put not approved and the date. 326-08 Swindell v. Sindana.
Noel McLean appearing on behalf of the respondent Tucker Sindana, and I believe that Tucker is also present.
And this is literally like a month later. Like.
Yeah.
And we have Ms. Swindell. Be just a second here.
Like, what is she on?
Your Honor, Sherry Evalt, guardian ad litem.
Thank you. All right. So with that, I believe this is on for a request to adopt the recommendations of the guardian ad litem. If you want to go ahead.
Me, Your Honor?
Yes.
Okay.
It's your request.
First, I wanted to apologize for how I've been mishandling my paperwork. I am currently trying to learn how to navigate the legal system, and I've spent countless hours in the courtroom with my 2-year-old trying to make sure things are filed properly. I would also like to talk about the TikTok videos that Mr. Sindana has referenced. The videos he cites with the Nicki Minaj song, which include the lyrics, "I just fell in love with a gangster," is simply a part of a popular trend and gesturing of the flipping of the bird.
Yeah,
And the
yikes.
video was not directed at anyone in particular. It is important to note that Ms. Gopal herself has posted
Yikes.
similar photos of her flipping the bird with captions like, "I guess I win again," after court. I have multiple photos and videos of me doing this.
I have no idea what
directed
she's talking
at
about.
nobody
Yeah.
Specifically. The second video, I also used a viral sound that thousands of people have used, and I titled it, "When Your Ex Finally Pushed Your 6'4" fully reformed ex-convict to his limit." It was to try to make light of an incident that had already happened in the past where Mr. Sindana, when I showed up to Mr. Sindana's house to drop off things for my kids, at Mr. Sindana's home, a visit that he was well aware of. When I arrived, he refused to let the children come out to meet me, which forced me to approach his home. When he answered the door, he was visibly armed and told me that I could not speak to the children while having confiscated their
I'm going
phone.
to object at this point, as this exceeds the scope of the declarations.
So, Ms. Swindell, you can only argue what's in the documents that you have filed.
This is the very first page of my document.
You know, they always seem to try to find a way to sneak in something when there is a way to put that information in. I don't get it.
Do we have a child present?
I'm sorry, yeah, my 2-year-old. I am waiting for my fiance to get home from lunch break to help me. She's just playing in the other room.
Okay. As long as it's in your declaration, go ahead.
Yeah. When I was there, I expressed my concerns then at the time for parental alienation, as he had taken my children's phone and would not let me speak to them and would not let them come outside to get the stuff that they had requested. Mr. Sandana has exaggerated this situation, falsely claiming that my partner, Mr. Musso, showed up to threaten them and him and his girlfriend, Miss Goebel. We went to court for that because he tried to file a restraining order, which was dropped. And Mr. Sandana has continuously claimed that my partner, Mr. Musso, is a white supremacist based solely on his appearance. Mr. Musso, while physically imposing, is not and has never been affiliated with any STGs. It is important to note that when he went to court to try to file a restraining order, he was not trying to change the parenting plan at any time. It was not until I filed to change the parenting plan because my oldest, my 15-year-old son, asked to live with me full time because him and his father had been arguing. After my children and Mr. Sandana moved in with Miss Goebel, she quickly became involved in our children's lives, including coaching our daughter's soccer team. While I appreciated her involvement, I was hurt by how clingy she became with our children, particularly our youngest, Jada. Despite my best efforts to build a cordial friendship with Miss Goebel, reaching out to express my appreciation, she often responded dismissively, rudely, or not at all. Though Miss Goebel has portrayed herself as a mediator in the situation, she has been far from impartial. She has made hurtful comments to my partner, such as she has a better relationship with my daughter, Jada, than I do. She has exaggerated incidents, including a remark I made about her appearance in a private text message to Mr. Sandana, and has said that I loudly proclaimed it in a soccer game, which was extremely untrue. I want to address the statements made by my father, Matthew Swindell. I've never accused my father of inappropriate actions towards me. However, I have accused him of inappropriate behavior towards my cousins, including one of which who lived in his home from the age of 7 years old. Additionally, the home I built next to my father's property was not a choice, but rather a condition imposed by my uncle Scott Swindell, who controlled my mother's trust, controlled the trust left to me by my mother. He restricted my ability to purchase any other property, forcing me to build next to my father, the property that him and my father both owned. The truth is, I never had a meaningful relationship with my father or his family during the time I lived there. I did ask to move in with my father in 2012, but this was only after Mr. Sandana's mother physically assaulted me in front of our 3 children. We were living in her house. It was a very rundown house, and we're all 5 of us living in 1 bedroom. Mr. Sandana was not working at this time. After a month of living with my dad, I was able to get a job and a home for me and my family. I have very vivid memories of my father verbally assaulting and degrading me from ages 11 to 17.
Why is she giving them all this?
I'm assuming that there must have been some type of allegation that she was sexually abused by her father, and so her ex-husband does not want his kids around her father, whom apparently lives next door to her, because she does have a trust that is not, that I guess apparently controlled by another family member, which makes no sense.
Yeah, this doesn't make any literally any sense.
Why would your father and your uncle have control over your trust when you're in your 30s? A trust that your mother set up when your mother is not blood related to them. And your father shouldn't have. Well, I guess it depends, because some trusts are also not relinquished until you're at a certain, it could be either 18, it could be 21, it could be if you finish college, it could be if you get married, whatever the case may be. But that all doesn't really make sense. And honestly, you could have gone another route to get a house, but you just were not working, and so you had to. I mean, what is she complaining about? The damn house is already paid for too. Like, make that make sense.
Yeah, there's too many. There's too many weird factors here. There's too many, things that I don't quite understand because I was like, why is this all?
Because I don't know. Some of the stuff she's talking about was
Right.
not brought up previously.
No, and it should have
You
been.
know, well, I'm guessing that's because she wasn't doing the right thing as far as getting the orders and stuff together. But
Maybe.
I don't even remember his attorney bringing up any of this stuff.
No.
So I think
No.
she's just trying to word vomit
Possible.
everything she can possibly think of to
Very
to
possible.
have things go her way.
Yeah, very possible.
Yeah.
Have memories of him touching me inappropriately. However, I lived in his home when one of the inappropriate actions towards my cousin occurred, which eventually led to her running away as a senior in high school. Throughout this case, I have been open about my mental health struggles, and I have actively been working with my therapist,
Yeah.
prescriber to manage my PTSD, depression, and anxiety. While I have had one attempt in my past, Mr. Sandana consistently exaggerates this, falsely claiming that I have had multiple attempts. He also manipulates my marijuana use, even accusing me of using hard drugs earlier in this case. Contrary to what Mr. Sandana claims, I have never expressed a desire to smoke marijuana with my children. His accusations are baseless, and I believe it is fabricated to further his smear campaign. My primary concern has always been the well-being of my children. I have attempted to raise important issues with their doctors. Despite this, Mr. Sandana failed to refill Jackson's medication after March 19th, 2024, when he was placed in his care. Without consulting his doctor, while stopping the medication may ultimately have been Jackson's choice, the sudden discontinuation could have serious side effects, and I believe that these decisions should be made with medical guidance. Your Honor, my concern in this case has always been my children's mental health and well-being. I feel the smear campaign orchestrated by Mr. Sandana, Miss Goebel, my father, and Kristen Otto is designed to discredit me as a mother. While I am not perfect, I have been doing everything in my power to heal from a lifetime of abuse and trauma. I'm working closely with my healthcare providers to manage my mental health, and I will continue to fight for what is in my children's best interest. The GAL report reflects the best interest of my children, as it should. However, it is clear that anybody that doesn't side with Mr. Sandana becomes a target for his attacks, further demonstrating the manipulative tactics. Despite everything, I will never stop fighting for my children, and I trust the court will see the truth behind these accusations. I also want to bring up the fact that our court hearings have been all recorded and posted on YouTube, and then a TikTok account was made in August to also post all of those. They have reached over 120,000 views. I talked to the court. I went to the court the day I found out, and I asked them if these were posted on YouTube, if anybody has any way to access them. They said no, that the only way anybody could access them was if they were logging into our Zoom courts and recording them. I feel like this is part of another part of his smear campaign, that he's orchestrated other people to come into our court hearings and record them.
They have the right to be. Yeah, the people that get upset about finding about their hearings on YouTube always think it's their ex is involving somehow, but I doubt it's common, which leads me to my point.
But
it's
I'm
public.
So sorry to interrupt you. No, but here's the thing. When this is being done, when the hearings are probably being done, they are not on YouTube.
Right.
But people, and I mean, when I say people, I mean an ordinary citizen can
AKA
go to
us.
the court and do a request for like a release of information. Anybody can request the court documents for their particular case.
Right.
But this ending up on YouTube has nothing to do with
nothing.
the parties in the case.
No.
Like, these videos are even being posted by someone who has actually like no connection to the case at all.
None.
So, and weren't some of these court cases live on Zoom too? I mean, live on YouTube.
They were recorded on Zoom. Yeah.
Well, they're always things like that are always recorded, but they can't get to YouTube unless they've been made available somehow.
Nope.
Yeah. Because even the only person that can record the Zoom is the host.
Right.
And the host is the only person that gets access to the recorded video.
Right.
And I mean, the only other people I think that would join a Zoom link to these cases would be other people who have the same link for their own case.
Right, exactly.
And she can see who's in the Zoom.
Right.
There's a list of participants. Okay, this is a little bit gripping at straws here.
I'm hoping that the court takes what the GAL
True.
has to say seriously. It makes several claims that Mr. Sandana is very controlling, that his children have claimed that he is very controlling and make him feel uncomfortable. That he stands very closely to them to monitor any conversations that I have with the children. I believe that this is very unhealthy for my children, and it needs to be addressed.
Thank you. Ms. McLean?
Thank you very much, Your Honor. So first off, obviously, I am concerned about the declarations submitted by Ms. Swindell that don't comply with the local court rules and the additional declarations that are beyond the page limits and the pagination of that. So I'll just point that out to the court and leave that to the court's determination as to what you consider as it relates to those issues. And as you commented earlier on this docket, the guardian ad litem report is simply that. It's a report, and it's totally up to the court to ferret out the evidence and make a determination on what the court believes is in the children's best interests. In regards to the facts that are outlined in the guardian ad litem report, we've submitted my client's reply declaration as well as 2 witness reply declarations outlining the irregularities and the concerns as it relates to the inaccurate information or factors that were submitted as part of the guardian ad litem's report. And again, ultimately, it is the court that is to consider the facts and the information, weigh the credibility of the parties, and ultimately make the determination on what you believe is in the children's best interests. I would submit that given the substantial differences in the information that we've provided in the declarations, that this is something that a trial court needs to hear. I believe that I've noted it up for mandatory settlement conference assignment. We haven't had a mandatory settlement conference yet, so we'll participate in that process. And if we're unable to reach an agreement, then ultimately it's a matter that needs to go to trial. I would note that first off, there has been absolutely no substantial change in circumstances in the factual scenario of this case since the temporary orders were entered. And Ms. Swindell has now been removed from that joint custody that they were previously exercising since early this year. And because of her own behaviors, totally within her control, her own behaviors have resulted in her not having any contact with the children since May of this year. So she's been 5 months without contact with the children. And the court has ordered her in 2 separate orders. One, your contempt order that was entered on July 2nd, and as well as the order that you entered on September 17th. Both of those orders required Ms. Swindell to participate in a new collateralized substance abuse evaluation within 30 days. We are 3 months removed since the July contempt order was entered, and she has provided absolutely no proof of any efforts to stop smoking marijuana, no proof that she has a clean hair follicle in UA, no proof of a collateralized evaluation. So right out of the get-go, we have absolutely no verifiable information
One, that her prescribing physician has, or psychiatrist, has approved her use of marijuana to treat her PTSD, depression, and anxiety, as she suggests. Those are significant concerns, particularly in light of her past behavior as a result of her depression with a attempt with the children in the vicinity. It's also concerning when you take a look at her reactive nature during the pendency of this case. She certainly cannot control her reactions to benign emails of information that are provided to her. She has to react and engage in conflict. And as the court knows, there's multiple studies about how dangerous conflict is to children. She attempts to switch it up and suggest that Mr. Sandana is the one, he and his girlfriend are the ones that are engaged in conflict, but you have no documentary evidence or factual evidence to support those baseless claims. So at this juncture, you have a mother who, again, holds all of the answers to her concerns, and that is she needs to get clean. She needs to do those evaluations that the court ordered and follow through with her mental health. And she herself identified that her mental health is a concern and that she's done all of these things, and yet we have no verification that she is stable. In addition, it's concerning that her marijuana use is somewhat normalized in the guardian ad litem report and recommendations. The recommendation from the guardian ad litem was, well, maybe she needs to do a substance abuse evaluation. The court's already ordered that and she's not complied. We have concerns that as it relates to her own documentation that we filed from her mental health provider, where Ms. Swindell identified that she was an habitual user and she was engaging in excessive cannabis use, and that was also adopted by her counselor. That was one of the findings. That's from November of 2023.
Oof.
The Columbia Wellness Record acknowledges that there was an increased risk due to alcohol and substance abuse. Couple that with the CPS records, where the oldest child is reporting to CPS that he's aware of mom using, he's observed mom using, he's observed her using a vape pen and a bong. And again, we're talking about an impressionable child who was 14 at the time, now 15.
Right.
Couple that again with the fact that one, we are here because of her behaviors, and her immediate concern was addressing those TikTok videos. She, the TikTok videos, as well as the court hearings that have been streamed. We have absolutely no control, and I don't know what control the court has over somebody recording those videos. We're aware that we're not allowed to do that. My client tells you he has not done that. My client has provided you documentation where he has reached out to the one of the posters, one of the individuals who post, or the identifier who posts those videos, and there's been absolutely no response. My client, his girlfriend, Ms. Swindell's father, have not video recorded those. And you'll even see in my client's, I think it's Exhibit C, is this is attached to his declaration that we filed on September 17th. Oh, I'm sorry, not that one. We filed it on September 26th, where Ms. Swindell engages in communications about at least her perspective of this. And you can see where there's multiple other hearings from different jurisdictions that are populated under these sites. But simply to point out that my client has not done that.
Yeah, I understand.
Too is concerned about the children seeing that. And go back to Ms. Swindell's TikTok videos that she herself has posted, and she has hashtag divorce and hashtag co-parenting struggles. Those are things that her children can see, and she's the one posting those, and yet she's complaining about these hearings being potentially available to the children. The children can search her name and see her TikTok videos. Extremely unhealthy, particularly following these hearings. My client tells you, and his significant other tells you about the concerns where, first off, Ms. Goebel was asked to be essentially a mediator between the parents, the suggestion by the GAL about her being the mediator, and yet her advising Ms. Ewald about the significant other of Ms. Swindell, Mr. Musso, one, his felony history involving very dangerous assaultive convictions, and two, the ongoing threats of him essentially being the heavy to enforce Ms. Swindell's wishes. That type of optic is not good, particularly when you have an individual such as Ms. Swindell who's invested in drama and conflict. The declarations outline significant concerns about the disruptions during some of the interviews, the nature of some of the conversations. Even Ms. Swindell in her argument says, you know, I've never made allegations against my father. Look at the guardian ad litem report. The guardian ad litem report in and of itself acknowledges that the father, the grandfather, maternal grandfather, should not be present because of the, and this is number 12 on page 24, due to mom's statements regarding her childhood abuse by maternal grandfather. Maternal grandfather should not attend any event or function. That's the guardian ad litem's conclusion based on Ms. Swindell's own statements to her that she was abused as a child. She says something completely different today. So
Objection. I believe I said I was not abused by my husband or by my father.
Okay. All right, wrap it up, Ms. McLean.
Okay. So our position is that the court should not adopt the recommendations. Ms. Swindell has not complied with the court orders. She's continuing to use. We have concerns that she continues to not be mentally healthy, and we believe that the court should deny the request, adopt my proposed order that I've submitted to the court, and award my client $1,500 in attorney's fees for having to respond to all of this.
So whenever I need more space in my wardrobe, I sell everything I don't wear anymore on Vinted. Download Vinted.
What's the secret to peak health? Going micro with Noom. Micro habits, micro wins, even
Ewald, anything you wanted to add?
Yes, Your Honor, thank you. You know, I understand the party's not loving the report all the time, but I did have the opportunity, a unique opportunity that I've been able to speak to all parties, including the references and the collateral. I've been able to see the substance abuse evaluation that was done. I've reviewed medical records. I stand by my report. I'm very comfortable with it. These children are older, and my job was to be their voice, and their voice is that they would want to be with their mom and dad. Both mom and dad are good parents. I didn't say they weren't. And I firmly believe that that needs to take place. I did review my recommendations. I don't see anywhere where it stated that I felt mom needed to have another substance abuse evaluation. Noelle, Ms. McLean had brought that up. I don't see it in the recommendations. I didn't review the full report right now, but I do stand by this report. I'm very comfortable with my findings.
Thank you. Ms. Swindell, keep it short. I still have other cases. You have a chance at rebuttal.
Yes, ma'am. Thank you. I would like to say that I did do a substance eval. It was April 23rd, 2024. I had given Ms. Noelle the copy of the substance abuse evaluation that said no treatment is recommended at this time and that I have no substance. Mr. Sindana did not reach out. They claimed that I gave them the wrong number, which I followed up and corrected my typo. They're trying to say now that I did not give them the right number, but I did. And he has called the substance abuse lady, Michelle Buckles. He's called and given her collateral information that did not change anything, and he's unhappy with that situation. So he wants me to complete a whole nother one. I don't think that that's fair. I think that he is, anytime anyone doesn't side with him, he's going to want something new. And I think that this is an abuse of power, and abuse of money, quite frankly. And I just hope that you see what's in the best interest of my children. I'm, like the GAL said, we're not bad parents. We have conflict between us. And I'm hoping that that conflict can be resolved and we can move on with our lives. This is absolutely out of hand.
So I did review the files and record, the statements that have been filed. And the court recognizes the guardian ad litem spent a lot of time investigating this matter and appreciates the work. And again, as I say, guardian ad litem reports are a recommendation. Clearly, there are disputes as to what's been said, which is not necessarily unusual either. Clearly, the parties see things differently, and there's only one way to get this matter resolved. And so the court is not going to be changing anything at this time. And the matter needs to get noted for trial. I think you said there's an MSC.
I believe that I noted it up for an MSC. I apologize. I should have looked at that date.
When is it? November 18th.
Yes.
Okay. So Ms. Swindell, do you know what MSC is?
Kind of.
Okay, so it's called MSC for Mandatory Settlement Conference. And it's an opportunity to meet with the judge. That judge then recuses himself after hearing in the MSC. But basically, the attempt is to see whether or not the parties can reach an agreement rather than proceed to trial. So that's the idea of an MSC, is to see if a settlement can be reached between the parties.
And there is more information available on the court's website that she can access, and we can forward that link to her if she needs it.
Okay. So why don't you go ahead and just do that, Ms. McLean, if you would. And so that will be happening. But bottom line, the matter needs to get set for trial. It needs to be heard as a whole as to what needs to occur. As to the request for attorney's fees, the court understands why that request may be made, but I think Ms. Swindell properly brought the matter before the court. And the court doesn't find any fault in that, just not agreeing at this time to make changes. So.
Do you want to do a presentation, or do you want to make adjustments to the order that I did provide to you, or?
So what I would suggest is just get me a clean order.
Okay.
And if you can't come up with a signature by both parties, then note it on.
Okay, I can do that. Thank you.
Yeah. Right, number 11, you say?
I do believe it's number 11, the Swindell and Sindana matter.
24-3-2608.
And I just, sorry, Judge. I just entered my notice of appearance yesterday.
Look at that. Mom is actually hired an attorney. Miss Bush should help smooth things out.
My understanding is we can strike today.
Or if you have the document in front of you, perhaps you could just acknowledge that Ms.
Just a little thing I'm noticing, and I know that we didn't watch the other case that we had watched that had the 14 hearings. We hadn't, done this because, for just context for everybody, the 14 hearing one that we watched was 6 hours long. So that would have not necessarily been something we would have
It was incredibly long.
Yeah. So he will understand what I'm about to say, but we're kind of familiar with this court because I think we've watched the 14 hearing one was the same courthouse. A lot of the judges that we've seen in these 7 hearings, we saw in the other one.
Right.
So I say that too to say, if you remember, when that lady from the 14 hearing case Remember, she got an attorney finally.
Yep, same
And
thing.
remember how that attorney talked super fast?
Super fast.
I think we have another one. We have actually both attorneys in that one were talked very fast. So I kind of like this
Yeah.
Miss McLean person because she's very like
Yep.
articulate and steady talking.
Right.
But I don't like the fast talking. It's
It throws a lot of things off too. Like it throws, it's like, why do you have to talk 100 miles an hour? Good God, slow down.
I mean the slower they talk, the more they get paid, right?
That's what I think, right? Slow down a little.
All right, so
But-
this is our last one, and it's actually maybe like not even a whole 6 minutes. So
Yeah, that's fine. We're
We'll see
okay.
how this
We got
goes.
plenty of time.
Approved by Zoom.
And that's fine with me as well.
I'll have to, hold on here, let me get the folder. Okay, so I do have the order that was sent over by Ms. McLean, and that's the order that you are approving, Ms. Bliss?
Assuming that's the order I saw yesterday, I'll defer to Ms. McLean, but I did sign off on the order that she presented me yesterday.
Yeah, it should be the 2-page order that both I and Ms. Evald had signed.
She's trying to get her custody back.
That's what I have.
Okay, then yes, Judge, you can enter my approval via Zoom.
Thank you.
Thank you, Judge.
Wait,
It's been
oh, that was
12
it.
months since they stopped streaming on Zoom in this courtroom, but a lot of things have happened in this case since then. Ashley seemed pretty happy with what was in the GAL report, which is why I think she was trying to get the judge to adopt it right then. But it's not unusual for the judge to leave things alone and let them try to figure it out on their own first at a mandatory settlement conference. And speaking of the mandatory settlement conference, 2.5 months later, they had their own mandatory settlement conference, but to no one's surprise, they did not reach a full agreement. Even though they didn't come to a full agreement during mediation, it seems like their attorneys continued to negotiate in the background, and over the next few months they were able to come to agreed orders on several things, including the recording of phone calls. Several months after those agreed orders, in August of 2025, Dad petitioned the court for permission to move with the children, and it seems like the move was related to military service, so if we take that into consideration, as well as the fact that courts rarely turn down a move by the primary residential parent if it will benefit the children, then I'm fairly sure that this move would have been allowed. While it isn't explicitly stated, it does appear like the move went ahead. Of course, that didn't stop Ashley from objecting. 2 weeks later, Ashley submitted to an observed UA and a hair follicle test. There are no additional entries about drug testing in Odyssey after this one, so I have to assume that she passed the test, as I'm fairly certain they would have mentioned a positive test on the record.
True.
The attorneys must have been working diligently behind the scenes to come to a fair agreement for both parties, because just a month after Ashley's UA, Judge Fassett signed all of the final orders in their case, making them officially divorced. This includes a decree of dissolution.
Child
She also
support.
issued a restraining order, although it doesn't say why. The divorce decree also comes with several judgments that relate to the division of their property.
It sounded like the sound actually cut out.
They each walked away from the
No,
divorce with their own
I
house.
think the person that was talking, they just stopped
Yeah.
and then continued. I guess I'll just, well, no, let's let them read it because I have to play it anyway, right? But I just
Right.
wanted to see this. So, it looks like the house had to be sold.
Boo.
Well, he moved, right?
Yeah, he
So why
moved,
not? But all these things still say active. I wonder if she ever paid those attorney's fees.
With the
Okay.
properties being of similar value. Both
Probably.
are 3-bedroom, 2 baths, but Ashley's place has a larger square footage. This is the home that Ashley was awarded. I'm sticking to photos of the inside as a consideration for their privacy, as I don't know if they still live there or not. With the relocation motion made by Dad, it's possible they don't. This is the house that Dad received, and it's just as nice as Mom's. They seem to have done a decent job of splitting their assets fairly. In addition to those property judgments, there was also an award of $404.43 for court costs and a chunk of prejudgment interest that Ashley was instructed to pay, probably because she still has an outstanding balance on the contempt judgment that she was supposed to pay earlier.
God damn, that interest's like $200.
The
Yeah.
divorce is showing us complete, and the final entries in Odyssey show both of the lawyers in the case withdrawing. They settled all of their issues without going to trial.
Wow.
The only other bit of information I was able to find about this family is a lien against Ashley's property from DHHS back from August of 2024 for $976 that she owes in back child support. I have no idea if the money has been paid off, but the records seem to show that it's still owing.
Wow. Oh,
I'm glad
still
that
more.
Ashley had a decent lawyer going into the settlement conference. She needed someone who could stand up for her against Attorney McLean. The amount of custody time she was awarded should be based on the evidence and testimony and not fancy legal moves or a lack of understanding on how to file documents. Miss Bliss will have made things fair for her, and then it'll all come down to the best interests of the children. I hope they can stay out of court and away from filing motions for contempt. So far, so good. I wish them all the best in the future. Thank you.
Okay, so I guess that's a good one.
Right. It turned out to be good. It turned out to be actually really good. With that being said, guys, we are done for today. We will be back tomorrow to do more. Have a good day, and we'll see y'all when we see you.